Good morning. Can I welcome everyone to this, the 33rd meeting of the Justice Committee 2013. Can I ask everyone please to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent. No apologies have been received. We're moving on to our fifth evidence session on the Criminal Justice Bill at Stage 1. We have two panels of witnesses today. We'll be considering provisions on corroboration and related reforms. You've got to at last, committee. And we'll be hearing evidence from the Lord President and later from the Lord Advocate. So I welcome to our first panel Right Honourable Lord Gill, Lord President of the Court of Session. Good morning. Roddy Flynn, Legal Secretary to the Lord President, and Elsie McIntyre, Deputy Legal Secretary to the Lord President. Also good morning. And Lord President, I understand you wish to make a brief opening statement.
Thank you very much, Madam Chairman. I just want to make three very brief points because I'm here today to give you the view of the judges. Different judges obviously have different points of emphasis, but what I would like to convey to you is the general feeling of the judges on this very controversial issue. I think there are three main points I'd like to make by way of opening. The first is that, in my view, the abolition of the rule of corroboration is a matter of constitutional importance. It's not simply a technical rule of the law of evidence that can be just changed as just part of a discussion of evidence. In my opinion, it's part of the constitution of this country, and it is one of the great legal safeguards in our criminal justice system. That being so, I think that if you're contemplating making a change of such profound importance, it should be done as part of a much wider consideration of criminal evidence and not simply done in an ad hoc response to one particular decision of the Supreme Court, which is the situation in which we find ourselves here. The second point I would make is that there is a remarkable degree of opposition to this across the entire legal profession. And I'm not suggesting that that in itself is a conclusive consideration against the abolition of corroboration. Please don't misunderstand me on that. But what I do say is that where you have such a degree of opposition across the entire profession, it should, I think, give us all pause for thought, because these are the views of people of considerable experience in the practical operation of the criminal justice system. And the third thing I would say is this, that throughout this controversy, the point has been made time and again that other countries can do without the rule of corroboration, and why Scotland out of step? I think that's the wrong way to look at it. I think, in fact, we should be very proud of the fact that we have something that other jurisdictions do not have. It is one of the great hallmarks of the Scottish criminal law. I take the view that we are all privileged in Scotland to live in what is a just society. And the reason for that is that our criminal system is rooted in the idea of fairness. And corroboration is, in my opinion, a critical element in that. So I'm not here to apologise for the fact that we've got corroboration. I think we should all be very grateful that we do. Madam Chairman, those are really the three main points I'd like to make. It may be that in the course of the committee's questions, I may be able to suggest other ways out of this problem, but that is the general view of the judiciary. In preparation for the consultation response of the judges to the Scottish Government's consultation, I asked every judge to express their view individually to me. And I have to tell you that, with the exception of my colleague, the Lord Justice Clark, all of the judges were opposed to the abolition of corroboration.
I was just going to say, wow, because, well, you've cheered me up, I can tell you, because and my position on abolishing corroboration is well recorded. It might not be my colleague's position, but I'll take questions now. Elaine, followed by Margaret, followed by John.
Thank you, Convener.
Followed by Alexon.
I appreciate what you're telling us about the views of the justiciary on this. However, the views of organisations which support particularly sufferers of domestic abuse and sexual abuse seem to take a very different view, and they make the argument that if corroboration would, first of all, if corroboration were abolished, that there would be more prosecutions of domestic and sexual crimes, and also that that the verdict, I suppose, would rest on the quality of the evidence presented in court rather than the quantity of evidence in terms of the requirement for 2 pieces of independent evidence. I just wondered how you would respond to those particular points.
Well, obviously, it is a matter of concern to ensure that sexual crime and domestic abuse is properly and effectively prosecuted. It is in the nature of that type of crime, or sorry, those types of crime. It's in the nature of those types of crime that proof is difficult. That is just a fact of life, and I think that what we should be very careful about is the risk that by legislating in an attempt to cure one perceived problem in one corner of the criminal justice system, we in fact make a reform, the consequences of which are completely unknowable across the whole spectrum of the criminal justice system.
So is there an alternative to this that would actually address the problems with domestic and sexual crimes? I mean, it's been suggested to me that you could maybe have a pilot where you abolish the need for corroboration and for those particular crimes and to see how successful it was, or whether in fact you can further amend what is considered to be corroboration to actually make it easier to prosecute those crimes.
I think that would not be a wise method of legislation, because if you legislate specifically for one particular type of offence and relax the evidential requirements in respect of that, then in a sense you create a privileged class of complainers in those particular types of crime, which I think has an unsettling effect on the rest of the criminal justice system. I think if you are going to legislate on this matter, it has to be legislation that applies across the board.
And there's no further development of what is considered to be corroboration, which would actually help to address the problems of those types of crimes, is it?
Well, you know,
changed over the years.
It's remarkable how corroboration has strengthened in my time in the legal profession and on the bench, because when I was a young lawyer, corroboration very often came in the form of a fingerprint. You don't hear very much about fingerprints nowadays, and of course the advances in DNA have been quite extraordinary, with the result that many crimes that 20 years ago would never have been detected, or certainly never prosecuted, can now be reopened and prosecuted successfully. I mean, I realise, Ms Murray, that's not entirely an answer to the point you're making, but I mean, I do feel that corroboration really works with deadly effect nowadays in the sort of cases I'm talking about.
Thank you. Margaret, followed by John, followed by Alison. Margaret.
Good morning. Can I say just how much I appreciate your opening statement, Lord Gill, because there has been a feeling that we're, you know, it's a done deal, corroboration will be abolished, therefore look at the safeguards. And it's been a particular concern that perhaps a third way hasn't been looked at. A third way, I think, would be worthy of exploration. That's retaining corroboration, but looking how we can improve the law of evidence. And while I know and have met with Rape Crisis and had very good conversations about their concerns, and I think a mutual agreement on some points, then people like adult survivors who have an experience of court have come up with, I think, some excellent suggestions on how that could be achieved. You've mentioned the progress in the quality of evidence, which should help, in theory, to make corroboration easier. They've mentioned the Muir-of doctrine, the fact that in practice in courts there is a time limit very often placed on the use of that. If that was relaxed, that would help convictions in these interpersonal type crimes and charges. And also looking perhaps at more training for procurator fiscals to understand why, for example, it might take 3 days before a rape victim comes forward, for the jury to understand that. Is this third way one that you think is worthy of looking at?
I do. I don't think it's wise to assume that if you abolish corroboration, you will increase the conviction rate. I'm really sceptical of this claim, because what you are doing is giving the defence really a very powerful speech, because instead of having to face a corroborated case, the defence can go to the jury and say, would you convict my client on the word of one person with nothing else to support it? I think that could be a very powerful line to take with juries, and I am not persuaded that this will lead, if corroboration is abolished, I'm not persuaded that it will increase the conviction rate. But to return to your main point, Ms Mitchell, if I may, I think that we should not just, as it were, take one brick out of the wall and say, well, we'll change this. It's a rule of evidence. We can change that. What you've got to think about is the effects of it on over the whole system. Now, the system that we have today is really quite coherent and logical, and it consists of a whole series of checks and balances which attempt to achieve not just fairness towards the defence, but fairness towards the prosecution as well. The overriding principle in all our trials is that justice should be fairly dispensed. I think that if you are going to make or to consider a change of such profound importance, then it has to be looked at against a wider picture. And my suggestion would be that there should be an examination of all of the various safeguards in the criminal system in the round. A reconsideration, for example, about the admissibility of certain statements, a re-examination of the use that can be made of confessions, a re-examination of the right of the accused not to testify, an examination of the right of the accused to withhold his defence at the earliest stage of a prosecution, and so on. These are all the various sort of tensions within the system, which I think the problem has to be looked at in that context. Now, at the moment, I think the legislative record of this Parliament over the last few years has shown that there is an openness to change and an open-mindedness that, you know, we should be looking at it in that wider context in order to reach what is the wisest outcome, rather than just, I think we're looking at this in much too narrow a context.
I mean, Convener, I think there's also concern. This committee is particularly under pressure. We've got lots of legislation. This is the second time we've met this week and the second time in recent weeks we've met. And there is a concern that we're not giving these important issues the time that we would ideally like to. In view of that, would there also be an argument, as well as looking at this third way, retaining and trying to improve and looking at all the very complicated issues, including the rights of the accused, which is paramount, as well as the defence evidence, for taking this whole issue out of the bill and properly considering it with some kind of body looking at it in depth? Do you think that would be a sensible way forward?
I think that was what I would suggest myself. In the past, the government's appointed royal commissions on these sort of things, or the appointed departmental committees, or so on. And I think that something like that it would be a very good way out of our difficulty here, because then I feel that a balanced judgment could be reached by looking at all of these various facets and the way in which they interact.
It's very helpful.
I don't think it would necessarily take a lot of time, and I don't think it would cause a great deal of delay. We have a very knowledgeable public in Scotland, and we have a knowledgeable profession, and we have academic support from the law schools. The issues are pretty well known, and it should be possible, I think, to come to a wise conclusion by looking at it overall.
I think that would allay some fears that perhaps by putting it into commission it's knocking it back. That certainly doesn't have to be the case.
No,
a commission could deal with it, as you say, and the issues are well known.
I mean, I don't think this would be a way of avoiding the problem. I think it would be a positive way of
tackling
getting a better outcome.
Thank you very much.
Can I ask, you said it wouldn't be necessarily be a very long time. I mean, give me some idea of a time scale if one were to.
I don't really know about that,
right.
but I don't imagine it would be in a matter of years if that's what
that's the thing I was thinking of. Yes.
No, I don't think so.
I've got others coming. I just want, because you've opened up the issues of, you know, looking at all the ways evidence is used in court just now. One of my concerns, and I don't know, you may not know the answer, is there's been any inquiry into why juries do not convict. Academic research into why juries, maybe when the Crown thinks they've got a terrific case, the jury doesn't convict, and into how juries think about things, notwithstanding we'll keep the anonymity of, but an academic research into it. Because I think that's another issue that we tend to not look at.
That's a big question, Madam Convener, because the restrictions on one's access to the views of juries are so tight that it's never been possible, I think, for proper academic research to be done into the ways in which juries come to their verdicts. You can't interview jurors, I'm afraid.
Should there be some academic research that does anonymise but that looks at issues? I mean, it does seem to me that sometimes we get, you know, perverse decisions, and it's not really to blame jurors. It's just why is it that with the evidence that's presented, this is another part of the whole drama, as it were, of the court, that we don't know why it comes to that view.
Well, I have to say it's not a subject that I've really got any sort of developed views on. I haven't really gone into that in my own mind in any great detail. But my experience has been that, by and large, juries get it right.
Yep. That's that one answered. John, followed by Alison, followed by Sandra, please.
Thank you, Convener. Good morning, panel. Good morning, Lord Gill. I, like my colleagues, was very reassured from what I heard from you. And I have 3 points, if I could put to you, Lord Gill, please. And it's things we've heard in evidence and aware of the terms of reference that Lord Carloway had. It's been suggested to us both in written and verbally that the proposal to abolish corroboration is a rebalancing act. Could you comment on that at all, please?
I think I would put the matter more strongly than that.
Okay.
I mean,
right.
I think you've got to think very carefully about what the consequences of this could be. It's not just a rebalancing act at all. It's a major change which has consequences that many of which are unknowable at this stage. And it's not just a piece of law reform in the narrow area of the law of evidence. This affects the whole approach of our society towards justice, and it could have consequences that could be very, very serious. By and large, we do not have many miscarriages of justice in Scotland, and when they are discovered, we put them right. But there are very few. My fear would be that there would be many more if corroboration were abolished.
Thank you for that. A further point we've received from a number of sources that, and you touched on briefly yourself, is that with advances in DNA, with CCTV, indeed with other covert surveillance, that there's an argument to be made there's less, there's more corroboration available rather than...
Yeah, well, there is, I think. The risk, though, is that if the prosecution don't need corroboration, in some cases they may take the view, well, why go looking for it? We've got the complainer, and the complainer's word may be good enough. My other worry, of course, would be that sometimes going looking for corroboration is costly in terms of police time and resources. And when you are dealing with scarce resources, it would be unfortunate if economies were made in that direction, if corroboration was available. And one last point, if I may, on this. Just imagine that you have a prosecution brought without corroboration. If the defence can show that corroboration might have been available, then of course that is another very powerful defence point.
Thank you very much. The points are covered. Thank you very much.
Alison, followed by Sandra, please.
Thank you. Well, I too welcome your comments. I'm very concerned by this profound change, and I've been calling for a Royal Commission for some time. I want to just pursue the likelihood of wrongful convictions a bit further, really, and fears that you've expressed. If we take them with other reforms that have been galloping through our system at the moment, like changes to double jeopardy and the proposals on the admissibility of evidence of bad character and previous convictions, and do you think that these accumulated kind of changes bring great risks?
That's my point. That corroboration has to be seen in that much wider context. And if you're going to consider a change of this importance, then those are exactly the other considerations that have all got to be taken into consideration.
Okay, that's helpful. Thank you. We know that in England and Wales they have a whole lot of other checks and balances that we don't have. And I'm not sure how useful it is to get into saying, well, it would be a little bit better if we had this instead of that, because I think your position is we really ought to set this aside and look at it in the round. Is that right? Yeah. Okay, that's helpful. Thank you.
Are you referring to jury size? Are you alluding to jury size?
Yeah.
And the 3 verdicts, I think, which nobody's raised. Is that the position? We should be looking at all of that or not? Or
I think if you say, well, in view of the abolition of corroboration, we'll change the majority from the necessary 8-7 to 10-5 or whatever. The moment you say that, you're actually conceding that by abolishing corroboration, you're creating a greater risk of a miscarriage of justice. And the fact that you then bring this safeguard in is, I think, an acknowledgement that by abolishing corroboration, you know, there is a greater risk of things going wrong.
Should it also involve the 3 verdicts, bringing in the not
Yes,
the whole thing?
that could usefully be looked at too, as part of the whole general survey of the criminal law.
Sandra.
Thank you very much, Convener. You did mention about the fact that you're looking at corroboration, and we're looking at criminal justice bill in the round, and it has been touched upon about the jury changes and double jeopardy and changes in various other parts of the law. So what you're basically saying is, in the Justice Committee, we should go ahead with the criminal justice bill, but corroboration should be taken out and looked at as a separate entity.
I think that would be a very wise course.
Chair, can I just follow on? I just wanted to clarify that point. Basically, following on from what John Finney had mentioned, you mentioned yourself about the advances in corroborative evidence such as DNA, etc. And obviously you said there were more corroboration available. And you did also say, and I think I quote you in some parts of this, was that if there's more corroboration available and you have a other witness, as you might say, you did say, why go looking for it? Now, I was quite, concerned about that remark, because obviously you've mentioned about the judges, the overall majority of judges are in favour of not abolishing corroboration, but we're also talking about victims here, not just the judicial system, who don't get justice in certain aspects, whether it be domestic violence, rape, also older people, children in children's homes where there's not a corroborative person. Now, if there is other corroborative evidence there without a other person, why wouldn't you go looking for it? You did say, why go looking for it?
No, forgive me.
I think that's not what Lord Gill actually was saying. I'll let you.
I don't think I said that.
I'd just like him to clarify that point.
I'm sorry if I haven't expressed myself clearly enough, but I'm as concerned as anyone if a crime of a sexual nature or a crime against a child or a domestic abuse goes unprosecuted and unpunished, because plainly that is a matter of obvious concern. But what you've got to be very careful about is that in attempting to provide a solution to that, you make a reform that it spreads across the entire criminal justice system. Because it wouldn't just, abolishing corroboration wouldn't just apply in the cases that you've mentioned. It would apply in every criminal case, and it would apply, for example, if any of us were to be involved in an accidental misunderstanding in a shop, and the shop assistant said, I saw you picking up something and putting it in
But you were saying that.
And if any of us found ourselves in that kind of situation, I think then we would begin to see the value of the law of corroboration. It applies very widely.
I just come in on the point that I was making. Yes. You haven't quite explained the point I was making. Maybe I've picked you up wrong, but you certainly did say, not you why go looking for it, but the defence would say, if we have corroboration, i.e. as a other person, there may be other evidence there, but why go looking for it? The point I'm trying to make is corroboration, DNA, video cameras, as has been said by Mr Finney, and other forms of corroborative evidence. If that is take the instance of a shop that you're mentioning, most of them CCTV cameras, that would corroborative evidence where the crime had been committed. But I don't particularly want to go down the road of somebody being accused of taking something from a shop. What I'm trying to say is justice served? Because defence lawyers, if they have another person, don't bother going looking for other corroborative evidence.
No, I was really thinking more about the case where the prosecutor who has to make the decision whether or not to bring a prosecution if he has the word of one witness, he may then say, well, that's enough. We can go ahead with this prosecution, and thereby fail to follow up other lines of corroboration, which I think would then present the defence with quite a good defence argument that you had the evidence there if you'd only gone looking for it, but you didn't bother. Mm-hmm. I'm sorry, that was really the only point I wanted to make.
Following, just sort of on from that, because one of the things that I get myself into trouble here, but here goes. One of the things I heard the Cabinet Secretary say, and I've heard it said before on behalf of Rape Crisis and Women's Aid, is that it's not about securing more prosecutions. It's about access to justice. And I don't know what that means. And I wondered if you'd like to comment on that, because I had thought that the whole purpose of putting this into the legislation was to secure more prosecutions. That apparently is not the case now. It's about securing access to justice. Now, I remember hearing that clearly on a television interview, and I've heard it subsequently, and I don't know what that means. I wonder if you'd care to comment.
Well, I think the only rational justification for this proposal must surely be to increase the rate of convictions. It must be. What other reason could there be?
Well, I'm agreeing with you. I'm just allowing you to corroborate what I think about it. But I just found it quite an extraordinary statement, as I thought that was the driving force, even if we narrow it to sexual and rape offences, although, of course, it applies across the piece. Yes. Alison.
Perhaps just following on from that, because, of course, we know that rape convictions in other jurisdictions are still very low and are not improved by not having corroboration. So there are other forces at work which stop either juries or people coming to conclusions about things like that. I think there's a real danger that we're moving from prosecuting in the public interest to prosecuting in the victim's interest. And I wonder if what the Cabinet Secretary is moving towards is that the victim should have their day in court. How would you respond to that?
That is not the basis on which our prosecution system works.
Of course not.
Our prosecution system works on the basis that the Lord Advocate makes the decision in the public interest as he sees it, whether or not a case is to be prosecuted. And it's a marvellous feature of our criminal justice system. The privileged position of the Lord Advocate as the head of the prosecution system is really one of the things that makes it so fair. He makes an independent, unbiased decision by looking at the case and deciding if it's in the public interest to do it. And if he says he's not going to prosecute the case, no one can gainsay that decision. And it's not for the complainer to say, I want the case prosecuted.
Yeah. That's helpful. Could I also ask whether...
Could you just let Christian and John... I'll let Christian and then I'll let you back in, and then John Finian. Are you on my list? You are now on my list, yes. So Christian, then Roderick...
Good morning, Lord Gill. I've looked at these papers and this evidence from a different background because, of course, it's only my second meeting at the Justice Committee. But after hearing what I heard this morning, I would like maybe you to develop a little bit more on the problem of access to justice. You did say at one point at the start that there were a problem in the judicial system and there will be we should somehow find solution to change it. And will the access to justice, will removing corroborations, will improve or will not improve the access to justice in your view, saying that it will be more about the quality of evidence than the quantity of evidence?
I don't think that this will improve the quality of justice in Scotland in any way. I think there's a very serious risk that there'll be even fewer convictions for reasons I've already given. And I also think that if you make this change in isolation without looking at the wider picture, you may find that there are consequences that at the moment are unknowable that could be very adverse to the system.
So do you think that we should not start by removing corroboration,
No,
or we should start with something else? Is
I
what
think
you
you're
explained, right?
starting in exactly the wrong place.
But regarding the access to justice, do you think, Lord Gill, that it would increase the number of cases to be brought to prosecution or not?
No, I
Definitely
don't.
not.
It might increase the number of prosecutions. I'm certainly not convinced it would increase the number of convictions.
I've now got Roderick. Sorry, I apologise, Mr. previously.
Thank you, Convener. First of all, can I refer to my register of interest as a member of the Faculty of Advocates? Lord Gill, morning. I've listened very carefully to what you've said, and to some degree that's preempted a line of questioning that I was going to embark on. To be fair to Lord Carlaway, however, when he gave evidence on the 24th of September, at questioning from me, he basically accepted that there was not necessarily the case under the new proposals and the new prosecutorial test that there would be more prosecutions. So I don't think one necessarily needs to be too harsh on what Lord Carlaway has actually suggested. I'll take your points on what the purpose of the change would be if there are not more prosecutions or certainly not more convictions, and take that on board. If we can just speculate for a moment, however, I've taken on board everything you've said so far, but the Scottish Human Rights Commission regard corroboration as performing a quality control function. What other quality control functions do you see in the system at the present time? And in a different system which wasn't relying on corroboration, what kind of quality control functions would you like to see?
I don't know, but I'm pretty certain that changing the majority rule isn't the answer. I think it's illogical, actually. If there is a good, solid intellectual case for abolishing corroboration, then there should be no need for any safeguards. The moment you say there have to be safeguards, then I think immediately you're conceding that it is going to create a risk of miscarriage of justice, which, in my view, it will.
And in terms of kind of things that they have in England, like Section 78 of the Police and Criminal Evidence Act, kind of statutory discretion to exclude evidence.
I'm sorry, I'm not hearing you. I beg your pardon.
In terms of provisions such as they have in England, statutory discretion to exclude evidence, do you think that that should be considered in Scotland, or are you happy with common law powers?
No. I'd like to make it clear that I am not here to suggest that the status quo in Scottish criminal law should be preserved, as it were, immutable and unchangeable. Every legal system has to constantly renew itself because it has to adapt to changing needs and changing circumstances. And so therefore it is perfectly right and proper that the Parliament should reconsider the question of corroboration, among many other questions in the criminal law. I'm not suggesting for a moment that the subject is off limits for discussion. Far from it. We can all benefit from looking again at all of our most comfortable assumptions and examining them to see if they're still valid in modern conditions. But what one ought not to do, I think, is to simply take, in an ad hoc response to one decision of the Supreme Court, just say, oh, well, we can change this particular rule of evidence. I just don't think that's the path of wisdom.
So basically, in a nutshell, looking at kind of other things in isolation is the wrong way to look at it. Is that your view? Yeah.
There are other rights of the accused, you know, that could usefully be looked at. For example, the fact that the accused can, as it were, withhold his defence until a fairly late stage in a prosecution, that is a point that could usefully be re-examined. And of course, the whole vexed question of the use of statements and so on. That again has been a constant source of trouble in the courts. But all of this can be seen as part of one general problem, which is just to keep the law just and fair and keep it up to date.
Thank you. I think we're pretty well, I mean, we've got supplementaries, but I think pretty well established the position. I don't want to have Lord Gill repeating himself over and over again on issues. If you've got something new to bring, John, have you?
Yes, I think it is. Convener, thanks.
We'll see.
we will, and Convener, I'm sure you'll keep me right. Lord Gill, we're to hear from the Lord Advocate next. And in advance of that, we've been given supplementary written evidence from the Crown Office and Procurator Fiscal Service. And if I read this passage to you, please, I would appreciate your comment. It's important to be clear at the outset that the abolition of the requirement for corroboration is not about improving detection or conviction rate. It is about improving access to justice for victims. The passage then goes on to cite a Supreme Court of Canada ruling from 1954, which says, and I quote, "It cannot be overemphasised that the purpose of a criminal prosecution is not to obtain a conviction. It is to lay before the jury what the Crown considers to be credible evidence relevant to what is alleged to be a crime." Are there frailties in that approach?
I think that that is rather a simplistic statement that is being made by the Crown. What is the point in bringing a prosecution unless there is a reasonable prospect that it will succeed? Surely the criterion in which prosecutions are brought is that it's in the public interest that a person should be prosecuted in order to be convicted and punished for the crime that has been committed. If it's simply to give access to justice, then that is not my understanding of the role of the Lord Advocate. But I may be wrong, of course.
And it clearly wouldn't be justice for the accused to be taken there on that premise.
Well, if you have a case that's unlikely to succeed, I'm not convinced that you're doing the complainer any favours by bringing it.
Many thanks.
I mean, it's an
court is not
it's
a
an
therapy
ordeal
for anyone, I
complainant.
wouldn't have thought. Alison?
I think Lord Gill's counsel has been very wise this morning. I think he's covered
Yes, I think we really,
most of
unless John, you've not had the opportunity to answer, please.
Just a kind of supplementary.
Yes, please. And then I think we really clearly know the position now. Thank you very much. But John, if you...
It was just along the lines, and I think, sorry, Lord Gill, your opening remarks did certainly raise the bar a bit with regards to the contention that's associated with this bill. And I know you also did say that one should not assume, but if we are, should the government get their way, that they are satisfied that the proposals provide sufficient checks and balances to protect witnesses and combative culture in our courts and the rights of the accused? Because so far, I think, I have heard the comment coming from more or less the professional bodies and the agencies, and not so much about the witnesses. So if the bill does get the go-ahead, what do you see any pitfalls or downfalls, or if it should appear in court, what protection do you think the protections that are within the bill is required?
I think if you alter the rule about the majorities, that certainly is an exercise in damage limitation. I mean, it will perhaps do some good, but my feeling is that this hasn't been fully thought through, and there could be some very, very adverse consequences. Yeah.
My breath's taking away. At least I'm going to. I think Lord Gill's position is absolutely, underlined, double underlined, and words like damage limitation. I think you can ask for any more. Do you wish to add anything further to the end of?
I'd like, if I may, just leave you with this thought, that this whole controversy that has resulted from Lord Carlaway's review has actually served quite a useful purpose, because it has brought out into the open a great many things that over the years we've just taken for granted. And it's always useful to re-examine your assumptions and see if they're keeping up to date with a very fast-changing world. I think it has been a useful exercise, but what I think it all points to is that what's needed is a wider and more general exercise in re-examination of all the checks and balances that apply. What I would say to you is this, though, that the rule of corroboration is not some sort of archaic legal relic from antiquity. We didn't get where we are by accident. The fact that we have this rule in our law, which I regard as one of its finest features, is a result of centuries of legal development and legal thought and the views of the legal writers, of politicians, practitioners, down through the ages. And it has been found to be a good rule. And I would say, listen to the wisdom of the ages. It has a lot to tell us.
Thank you very much, Lord Gill. And I'm going to suspend for, I'll give you 10 minutes because we've got the Lord Advocate to follow. Thank you very much. Thank you very much. Right, we're reconvening, and we now move on to our second panel of witnesses. We've got Right Honourable Frank Mulholland, QC, Lord Advocate, and Katrina Dalrymple, Head of Policy Division, Crown Office and Procurator Fiscal Service. Good morning. It's still morning, yes. Lord Advocate, do you want a brief opening statement, as I offer to the Lord President?
Yes, thank you, Chair. Firstly, good morning to everyone. Just a few opening remarks. I suppose the committee is concerned with the proposal to abolish corroboration, which I think has exercised most of the debate on the Criminal Justice Bill. So if I could say a few opening remarks about that. My view is I support it, and I support it for a particular reason. I see and prosecutors see the effect of the rule of corroboration on certain areas of criminal offending, in particular sexual offending, including rape and domestic abuse. It's particularly acute in relation to those areas of criminality. As women and children are and very much the majority as victims in that area of criminality, I see the effect of corroboration as being disproportionate in relation to women and children. So I support the abolition of corroboration for that particular reason. Further, there's a number of matters which have been raised by speakers to this committee. If I could deal with two of them in particular, and of course I'm quite happy to answer any questions that members have. But it's been said that the abolition of corroboration is particular in relation to increasing the conviction rate in relation to rape or sexual offending. I've never seen it as that. I've never ever said that the abolition of corroboration was all about increasing the conviction rate. I see it as access to justice for the victims of domestic abuse, rape, sexual offending. And it seems to me that that is something which any modern criminal justice system should have. It seems to me that there's a class of witnesses, of victims in these two areas of criminality that are denied access to justice for in particular the requirement of corroboration, the legal requirement of corroboration. If I could just illustrate this with some figures. Firstly, in relation to domestic abuse, 2012-2013, 2,803 charges of domestic abuse could not be taken up because there was insufficient admissible evidence. And that is, I would suggest, a matter of real concern that we are not giving the possibility, access to justice for certainly a sizable proportion of victims in those charges. So that's domestic abuse. The second one is in relation to rape. I asked yesterday if policy could give me the figures, say in the last 2 years, of how many cases or charges of rape that could not be taken up as a result of insufficient evidence. Although this is not statistically robust in the sense that it's not a full double-checking exercise, I wanted to have an indication of the type of numbers of charges that couldn't be taken up because of the requirement of corroboration. And it's about 13% of charges, rape charges, reported to the Crown. 100, I think, in 1 year and 70 in the second year. So it's 170-ish over a 2-year period. So I would suggest that that is a real cause for concern for anyone who's interested in delivering justice in Scotland. I should add that it's not, you have to ensure that there's fairness in any criminal justice system. I accept that. And all Scotland's prosecutors, certainly that I work with, are imbued with that notion of fairness. I can speak in due course about the checks and balances, and no doubt that I'll be asked about that. But the second matter is a suggestion that if corroboration is abolished, then the police and prosecution will only look for a limited amount of evidence, will not look for any additional evidence that may be there. I would have to refute that suggestion. If that is correct, if that suggestion is correct, then you would expect the police and prosecution to stop it currently at corroboration, 2 sources of evidence. They don't do that. We are under a duty under the Human Rights Act, under the European Convention of Human Rights, to deliver effective criminal sanctions, which includes an effective investigation, effective prosecution. There's a raft of case law, in particular a case Smith against the Majesty's Advocate in 1952, which sets out under common law the duties that the police have. I think the Chief Constable's already commented that that won't happen. It certainly won't happen under my watch as Lord Advocate. And the notion that you would wish to bring cases with limitations on the amount of evidence that could have been available, and you would want to present that to a court, to a jury, is a notion that I don't subscribe to. So other than those 2 opening remarks, I'm happy to take questions from members.
Thank you very much. It's very useful. Elaine, followed by Christian, followed by Alison, please.
Yeah. First of all, Lord Gill had advised us that in terms of the views of the justiciary, he had actually surveyed the justiciary about their views on the removal of corroboration, and all but one were opposed. Has a similar survey been undertaken with Procurator Fiscals in order to ascertain the views of the people on the ground, as it were?
No, not in the sense of surveying all members of staff of COPFS. No, we haven't done that. What I can tell you is that at the time of Lord Carloway's review being published, we had quite an extensive meeting in the Crown Office, which was attended by all the senior civil servants, or most of them, most senior civil servants, procurators, fiscal, including the 3 federation heads, the Crown Agent, the head of operations, the deputy head of operations. And we had quite a robust chat about it, about what the Crown's position in all this was. And at the end of that meeting, I didn't detect any sort of dissension amongst the leaders of COPFS. So the answer is no, we didn't have a full comprehensive survey, but that was an indication.
Yeah, it's not the view of the service overall, then it's the view of senior people within the service in terms of...
I think that must be the case, yes.
Yeah. Can I go on to really the effects on victims, because obviously that is, I feel like, the primary consideration in terms of the suggestions. You say that you don't think that would actually be a larger number of successful prosecutions, and this is about access to justice. I just wondered, in terms of the victim who goes to court, either who doesn't get to go to court now, and there's no longer the view that this isn't because there was corroboration, that's just because we didn't believe you. Or if somebody goes to court and the jury then doesn't believe them, and there are all sorts of reasons why people don't believe women when it comes to domestic violence or rape. It's about prejudices amongst the jury and so on. What is is that not going to have an even more deleterious effect on the victim, that they've gone through all that process, and it's her word against his, and at the end of the day, the jury doesn't believe you, and you basically are being perceived as having been lying? Is that not even worse for a victim than being told that they can't go to court because there's no corroboration?
Well, I'll answer it this way. In all my time as a prosecutor, and I've many years' experience, and I've been involved in many difficult conversations with complainers and charges of sexual abuse and rape to explain to them why we cannot take the case up. I've never known anyone to express thanks for not being able to take up the case. The contrary, in my experience, that they wished the opportunity for their version of events, their account to be heard in a court of law, with the possibility that the jury, with the burden of proof and all that, all the protections, would reach a verdict on it. Admittedly, people may not thank you for not taking the case to court, but could it not be even worse if you went to court and then were not believed once you got there?
you know, that actually
Oh,
you would go through all that process and then you're not believed at the end of the day?
I'm not saying there may not be some validity in what you say, but all I'm saying is from my experience in having these difficult conversations, I've never known that sentiment being expressed. Can I just to take your point one stage further? If, and it's a matter for the Parliament, if corroboration is abolished, the prevailing view amongst procurators fiscal is it will lead to much more difficult conversations with complainers' victims, because rather than say, well, in law there's insufficient evidence to take the case up, what you'll need to then do is you'll need to explain the reasons why the evidence is not credible or not reliable, and that will be a much more difficult conversation than explaining to a complainer, a victim, that there's insufficient evidence. But we don't shy away from that. We think that, as a point of principle, that to give greater access to justice for victims, in particular victims in two areas of criminality I spoke of, we think it's the right thing to do.
Christian, followed by Alison, please.
Thanks very much, Governor. Lord Advocate, good morning. Just going back into the access to justice in your opening remarks, you made your point very clearly, and you give us a lot of statistics. I'm not very keen on statistics. Sometimes statistics doesn't tell you the whole stories. I've seen in your supplementary evidence that you give us a number of case studies. Would you like maybe to develop one of those and telling us more about it?
Yeah, I mean, we thought about what these are real cases. We've anonymised them, and there are many more. I mean, I can speak from personal experience about the effect of CADR, because this is where it's most acute. Prior to CADR, in a rape case, you had fairly common. You had the victim complainer stating that she was raped by a named person. Now, the requirement of corroboration requires us to corroborate the crucial facts, and in a charge of rape there are three crucial facts. Firstly, you need to corroborate penetration, you need to corroborate lack of consent, and you need to corroborate mens rea, the accused's intention. Those are the three crucial facts in a charge of rape that you have to corroborate. Now, we know that in many rape cases, it goes back to Elaine Murray's point about the dynamic of this type of offending. It is fairly common, we refer to it as counterintuitive, fairly common for victims to think about whether or not to report these cases to the police, an allegation of rape to the police. They might want to think about it, they might want to talk about it with their family or their friends. It might not dawn on them. They may be unsure as to what precisely has happened. And there is the concept, a fairly common concept of delayed reporting. That's normal behaviour, we're told by the experts, and in rape prosecutions we will explain that to the jury. In pre-CADR type cases, during interview, it was fairly common for an accused person to say, yes, we had intercourse, but it was consensual. Now, in those circumstances, you have corroboration of penetration because you've got the complainer's evidence that she was raped, penetrated, and you have the corroboration from the accused's statement under interview by police officers. Now, post-CADR, the effect of CADR in many of these cases is that accused persons are saying nothing on advice. And I'm not being critical of that option being undertaken. That's just a fact. That in many of these cases, you don't have that source of evidence now. So the effect of CADR in many rape cases is that you're not having corroboration of penetration, because by the time it's reported, forensic opportunities are lost. They're gone. There's no point in taking intimate samples 1 week, 2 weeks after the alleged rape, and you won't get corroboration from that source. So we're seeing, as prosecutors, that in many rape cases where pre-CADR we would have had sufficient evidence, we're not now, and we can't take them up. And that, to me, seems a matter of real concern. And And there's other examples. For example, I'll give you another example of one that I dealt with about 3 weeks ago. I'll anonymise it. And Margaret Mitchell, I think, I've heard Margaret Mitchell speak on Murov and the sort of extension or perhaps a redefinition of Murov. But one thing you'll never get away from in Murov is it requires 2 victims, 2 complainers. Now, I had a case where 2 sisters who had been horrifically sexually abused as children over a period of many years by a relative, a member of the family. The girls were told that no one would believe them if they spoke up, that no one would love them if they spoke up. So they didn't speak up. But eventually, as adults, they got the courage to speak up and make a complaint to the police. Now, the reason why they made a complaint to the police was quite simply that they were concerned that a relative had access to children of their age. Now, we took the case up. We indicted the case in the High Court, and we were prepared to proceed to trial. But one of the complainers, one of the victims, mentally could not go ahead with it. We tried to support that victim through the process, to give her as much support as was necessary. We got medical reports on whether or not it was detrimental to her health. But at the end of the day, we couldn't force that woman to give evidence. And the effect of that meant that the whole case fell, because it was a Murov case. And that, to me, is something which, in this Parliament, this committee, public at large should be concerned about. So, and I make the point, which I think is a good point. I respect, people in the legal profession, their views. I respect the judges' views, police officers, everyone involved in the criminal justice system and beyond has an opinion on this matter. But they are not seeing the cases which cannot be taken up because of the requirement for corroboration. And it's police and prosecutors that are seeing this class of case. And one other matter in relation to the abolition of corroboration and the effect on women and children, the disproportionate effect. I'm saying that. I've heard others say it. I've heard others oppose it. But it should be a real matter of concern that United Nations Committee against the discrimination against women in a report published this year, in July of this year, supported this and called for the abolition of corroboration. So I would suggest that that's a powerful voice as well.
I think I have to say, and I think I say on behalf of the committee, we would wish to see these prosecutions being successful. We're not at odds about the victims of these crimes, having successful prosecutions. I think the concern for us is, given the substantial evidence we've had previously, and certainly from the Lord President on behalf of all the judges, High Court judges bar one, is that this may be counterproductive to those very victims that we would share your huge concerns about. And Lord Gill moved on to talk about a review of all the rules of evidence, some of which you've said about the right to silence, and whether if we looked at all that, because he made it plain he didn't want to see corroboration as set in aspic, but to look at it all so that the difficulties you find as a prosecutor might be overcome in a different way. And I'd like your comments on that proposal that he had, because I think we would all wish to see successful prosecutions, but the concern would be that this is not going to achieve for those victims what you and I and everyone would wish in public.
Well, a couple of points in relation to that. Firstly, if, on the hypothesis that corroboration was abolished, how would the Crown approach its work? How would the Crown approach its decision-making and whether or not to take up a case? Now, in the two written submissions that have been placed before the committee, A distinction is drawn between corroborative evidence and supporting evidence. I'm sure it's a distinction that everyone here will understand. I would not, and prosecutors would not take up a case without any supporting evidence. But that is different than a legal requirement for corroboration. Of course you would want to look at supporting evidence, evidence which supports what the complainer, the victim, is saying in reaching a decision. And we would apply the reasonable prospect of success test, looking at issues of credibility and reliability. So I hope that gives some reassurance to the committee about that. But secondly, in relation to your wider review point, which I think was maybe the principal thrust of your question. Look, I completely respect Lord Gill, as I do Lord Carloway, as I do all the judges in Scotland. They have a difficult job and they've got a view. But I've got a view as well, and the prosecutors have a view. And I read in the last couple of days Lord Carloway's review report. And it seemed to me that it was a major piece of work. It took a year. There was a review group, a reference group. There was 5 road shows. There were visits down south. There were visits to the continent. They spoke to experts. They visited the Criminal Cases Review Commission, Glasgow Sheriff Court, and various other matters. It's all in Lord Carloway's report. So it's an extensive piece of work, and this was his recommendation. And it's not his only recommendation. It's across a raft of areas. So my own personal view is that I don't think it's necessary to go down the road of, for example, a Royal Commission or having the SLC to look at it. But again, look, I respect other people's views, and if that's the view of Parliament, that's the view of the Scottish Government, and I'm quite happy to go along with it, and we'll contribute to any review. But just to reiterate, I don't think it's necessary given the extent to which the Carloway review its work.
I'll let other members pick up on whether they think Carloway's review was thorough with regard to corroboration. I think that could be, if you forgive me, open to challenge. But if other members want to pick up on it, I'll be very pleased. Alison, Margaret, Sandra and John Finney.
Thank you, Convener. Good morning. I absolutely agree no one should be beyond the reach of the justice system, and that we need to strive to do all that we can to help victims of rape and sexual assaults. But is it not the case that conviction rates are very poor across many jurisdictions and are not significantly different, for example, in England?
Are you talking about conviction rates for rape?
Yeah.
Well, I mean, it's well recognised that there are issues, and I think Elaine Murray hit on a number of the issues about public perceptions. A woman wearing a short skirt is asking for it. I mean, I completely disagree with that, but there is that kind of view out there, and it's very important that you counter that in the presentation of your case, and certainly through the National Sexual Crimes Unit. We've been using expert evidence in many of the, call them rape myths, to educate the jury as part of the trial process. That work will continue. The statistic is often quoted, I think it's 3% or 4% of allegations of rape reported to the police result in convictions. What I can say is that in relation to convictions in Scotland, in relation to the charges that are taken up, the conviction rate is running at about 48 to 50%. However, what I would say is, and I feel strongly about this, the justice system is not about conviction rates. The justice system is about delivering justice. And I have my concept of justice is it's justice to the accused and justice to the victim, justice to the public. So, conviction rate is a barometer of how you're doing, but it's not the be-all and end-all of matters.
So it can be clear that you think that it's important for a victim to have their day in court, as it were, whether or not it's in the public interest to prosecute?
No, I think it's important in cases where there is supporting evidence, there is an account or an allegation which is capable of being regarded as credible and reliable by a jury. that there shouldn't be any barrier to justice for that victim in horrific allegations. I mean, rape's a horrific crime. And it seems to me that in those circumstances where you have evidence which is supported evidence which is capable of being regarded as credible and reliable, those are the circumstances in which a complainer should have access to justice.
You quoted in your introductory remarks that 2,803 domestic abuse cases weren't taken forward, and you said something like 13% of rape charges hadn't been taken forward because of corroboration, lack of corroboration. But you've also been quoted quite clearly as saying that there will need to be rules for sufficiency of evidence. So how many of those cases wouldn't have been taken forward even with, without corroboration, but because there wasn't sufficiency of evidence?
We've done shadow marking exercises to ascertain how, what the proportion of those cases would be taken up if we applied a reasonable prospect of conviction test where there was evidence which was there was supporting evidence. Katrina Dalrymple was in charge of that exercise, so if you don't mind, I'll just hand over to her and she'll give you the figures.
The answer you're going to give is in relation to the figures you gave earlier, or whether this is the earlier piece of work, the desktop work that was done for Lord Carloway?
This is an earlier piece of work.
So you're not comparing the same two things this morning?
No, the shadow
so
work.
I'm not sure that answers my question. I mean, it doesn't help me much at all.
I think the issue that's been raised by my colleague is, given the remark by the Lord Advocate that it was a thorough piece of work by Lord Carloway, and that would embrace corroboration as well, because we appreciate there's other issues which are far less contentious. I'm looking at paragraph 7231 of the Carloway report, which talks about cases that were looked at by the Procurator Fiscal Service, by two Procurators Fiscals, one I understand who was active and one who was retired, and pronouncements that were made in relation to the number of cases that would have gone to prosecution, number that have been successfully prosecuted. And I mean, it since transpires that this was work that was done over a 3-week period. And it's only done by two PFs. And that was one of the basis of the empirical results if we got rid of corroboration. I think that that's what my colleague's asking about.
Sorry,
rather than what, which you're entitled to bring as well, obviously, is a separate matter. But and I'll pass this to you if you wish to follow it up.
I'm well aware of that, and I do think that it was a very brisk and not very thorough desktop exercise. But yes. I'm referring to your evidence this morning, where you gave us figures and asked us to suggest that we would be shocked that 2,803 domestic abuse cases weren't taken forward because there was no corroborating evidence. But you're not able to tell me how many of those would have been knocked out with the new rules of sufficiency of evidence.
No,
and therefore,
we are.
Okay, we'll hear that. Yes.
It may be helpful if I explain the broad shadow marking exercise that the Procurator Fiscal Service have conducted, and thereafter explain how we have narrowed that down and done an additional exercise in relation to domestic abuse cases. The purpose of the exercise was to assess the impact of the abolition of the requirement for corroboration on the prosecution service. We consulted with statisticians, and we took a relevant and random selection of cases that were identified in the region of 950 cases that had been reported to the Fiscal Service. The statisticians were confident that the sample size chosen provided a plus-minus 5% accuracy. So the results are designed to have a 95% accuracy and confidence level within them. Now, you'll have to excuse me because I am not a statistician, and I am a lawyer.
We might have one here.
I'm glad.
So if you get bamboozled, we'll get bamboozled.
The cases had been previously marked. They were real-life cases that had been reported to the Procurator Fiscal Service between October and November of 2012. We selected 6 present Procurators Fiscal. We conducted a selection process for these individuals. They were provided with draft guidance and the new prosecutorial test. The 6 people that were identified, we tried to replicate what would be a normal team within the Fiscal Service that would be making decisions on cases. So we had a broad range of experience. We had some people that were relatively recently qualified, perhaps not so ingrained in the whole corroboration mindset, and we had other individuals that had, in excess of 30 years' experience of working within Scottish criminal law. The 6 markers looked at about 160 cases each, and in order to avoid any contamination of decision, they were given access to the police report, and they were not aware at all of the initial case marking decision. So it was all done offline, so they didn't have access. They didn't know what happened to the case previously. There was no impact in relation to the forum, so where the case would be prosecuted, because ultimately the exercise was designed to assess the impact of whether more or less cases that would be prosecuted. The forum does not come into the equation when you're looking at the abolition of the requirement for corroboration. This exercise was conducted over, I think, the cases, there were 160 each that the prosecutors were given to do, and they were given their own time to do it. And then we conducted an analysis of the results. In essence, the impact applying the new prosecutorial test to the business that's been reported was that we saw in the mid-range of a 1% increase in summary cases, which is about 1,227 new cases reported. And in solemn, there was at the mid-range of 6% increase, which was an extra 721 cases. Now, you may ask me how that compares to Lord Carloway's exercise. It is kind of like comparing apples and pears, but we have managed to do a level of comparison. Annex A looked at 458 cases and I think an extra 141 sexual cases. The percentages that are quoted in that were the percentage of the cases that they looked at. And when you looked at Lord Carloway's figures and you looked at across the whole, you multiplied it out, so you looked at it across the whole business of all the solemn work, Lord Carloway's figures, our statistician worked out, within the range of around about demonstrating a 9% increase. So our shadow marking exercise that we conducted with 6 prosecutors who were identified and selected is not in any way inconsistent to Lord Carloway's exercise.
Just to clarify, was that
Yes.
9% being taken to court, but not...
9% increase in the solemn business taken to court.
Yes, but
yes.
Was there then any prediction
Yes.
put into that of how many would have been successful, which was the
No.
issue?
No, that's our job. That's a jury question. That's
Yes, it
not a
is.
job for the prosecutors to
But
decide
in Lord
whether...
Carloway's review, he makes the
No.
predictions are made about how many they think would have been successful.
Bearing in mind that our test is based on a reasonable prospect of conviction, so we are making an assessment based on the credibility of the allegation that there was a reasonable prospect of conviction before we decided to mark that case for prosecution.
It's a very important piece of evidence. Could we have that in some
yes,
form?
We have written to the Finance Committee because this information is in the financial memorandum, but we can certainly follow up with a letter to yourselves for ease
It's
of
in the
reference.
financial memorandum of the...
In the Criminal Justice Bill, yes.
Missed that out. I didn't see that one.
Yes.
My apologies.
It may be of assistance if I...
See that?
We were concerned. We have to obviously look at the impact of the business that's also reported to the Procurator Fiscal Service. And we needed to work with Police Service of Scotland to identify what increase in business is likely to be seen in the number of reports. And I'm sure the Police Service of Scotland will provide their own evidence in relation to the exercise that they conducted. But it may reassure the committee that the exercise that we conducted in tandem. We offered guidance to the police, as the Lord Advocate would, in relation to the reporting of cases to the Crown Office and Procurator Fiscal Service. In that exercise, the police conducted a similar sample size, and the increase in the number of reports was about 1.5%, which I think equates to another 3,720 cases being reported.
It's at page 44.
That's right.
Explanatory notes.
So you have to look at the increase in the number of the cases being received by the police, which was likely to be 3,720. Now, the way that the organisation is planning for this legislation, we thought 1.5% increase from the police was actually quite low. So what I did was I sent one of my team back out to the police station, and I asked them to review what it was that the police had decided to report in terms of the exercise. And it became apparent that in actual fact the police had made correct judgments in most of the cases, and there was very little in addition to that that we thought would meet the reporting test to the Crown Office and Procurator Fiscal Service. So in terms of the police exercise that was conducted, we are relatively confident in that as well. Ms McInnes, you followed on in relation to domestic abuse. The other exercise that we have conducted internally is looking at domestic abuse cases, because we were very aware of the access to justice and the barrier that is prevailing. We looked at an additional 328 cases that had been marked for no proceedings due to insufficient admissible evidence, and we applied the new prosecutorial test to them. Now, we thought that there would be an additional 1,000 domestic abuse cases per year that would be able to be prosecuted in light of our new prosecutorial test, which, when we look at the increase that we have demonstrated in the summary shadow marking of 12,1227, then it is clear that our assumption is that the majority of the increase in the cases that we are likely to take to court will be in the domestic abuse cases on the summary side of cases, and that is the evidence that we have to date in terms of the exercises that we've conducted. So I hope that's helpful.
Avoidance of doubt, would you just clarify the new prosecutorial test, exactly what that is? Because it might not just simply be without having corroboration. There's more to it, is there? So,
the test is...
Just for the record.
It's a test which is applied in other jurisdictions. It's reasonable prospect of conviction, whether it's more likely or not that the evidence presented to a reasonable jury would result in a conviction. There are component parts of it, obviously.
No,
you
I
need
see.
to assess that.
Submission as well, yes. Alison, do you want to follow on?
Can I just ask the Lord Advocate, when he first came to the view that corroboration needed to be abolished?
I've always thought it, but I've never said it because you know, I really worked in a system that had corroboration. I didn't think that at the time that really that there was much support for it. So I kept my own counsel. So no, I've always been of that particular view. It's not a recent conversion on the road to Damascus, but...
or road to the criminal justice bill either,
yes.
for that matter. Margaret, followed by Sandra, followed by John Finney, followed by Roderick.
Good morning.
Morning.
Could we tease out this other jurisdictions that formed the basis of the reasonable prospect of conviction? Other jurisdiction, what kind of factors were taken into account? What was applied?
Well, I think visited, spoke to senior prosecutors at CPS, England and Wales. We've also spoken to the DPP and the Republic of Ireland and beyond. I was at a recent conference, the HOPAC Heads of Prosecution Conference, where heads of prosecution in Commonwealth jurisdictions across the world. So we
specific, Lord Advocate.
Well,
what precisely was in their test that you looked at and applied to these cases?
Well, what we did was we looked at, you know, what their test was and the component parts of that test. So if you're applying that test, reasonable prospect of conviction, what you'd be looking at the principal allegations. So you'd be looking at the complainer's version, her allegation, her account. What you'd be then doing is you'd be looking for factors which would tend to suggest that her or his account is a credible and reliable account. So you'd be assessing factors such as is there supporting evidence for that account, circumstantial evidence, what is the evidence against that particular account, what's the counterbalance if there is any. You would then sort of reach a view on the totality of the evidence. And in Scotland, we don't look at a sort of complainer victim-centric evidence. We look at the allegation itself, whether there's supporting evidence for the allegation. And if we consider that there is sufficient supporting evidence, independent supporting evidence for the allegation, then we would reach the view that there was a reasonable prospect of conviction. So it's a whole load of factors. It depends on what the evidence is. It may be it's eyewitness evidence, it may be it's forensic evidence, it may be it's medical evidence. So it's very difficult to say in each, sort of give a generality across cases. It depends on facts and circumstances of each individual case. But what you're looking for is you're trying to ascertain on an objective assessment of the evidence as a whole whether there's a reasonable prospect of conviction. Then, as part of the process, once you've, on the hypothesis that you have reached the conclusion that there is a reasonable prospect of conviction, then you would apply what we call the public interest test. Is it in the public interest that you would raise proceedings? You would take into account various factors, such as the seriousness of the charge. You would take into account the antecedents of the person accused. You would take into account any mitigation apart from the information before you as to whether or not that is in the public interest to raise proceedings. So that's how we go about it.
I'm still struggling to understand what it is that's going to be introduced by way of law of evidence, the nitty-gritty of it, quality of evidence or whatever, that's going to be different from the system just now that you saw from looking at the Northern Ireland system, the Welsh system and the English system?
Well, it's a reasonable prospect.
Was I correct in saying it was based on looking at how it was done in England in the Carloway report and the two PFs that looked at the cases there?
No. When
in the English system, in the Carloway report, that research that was done by the Procurator Fiscals, did they compare it with if it had been prosecuted under the English jurisdiction?
No, what we needed to do was we needed to...
Could you answer that question, please?
I'll endeavour to answer it. What we're doing, or what we did, was we looked at what test...
No, I'm asking about Carloway just now specifically. We can go back to the research you've just done.
But the test didn't come from the Carloway report.
I know, but I'm asking you just now about the Carloway. You've mentioned other jurisdictions for this new test that you've done after the Carloway report test was found lacking. I'm asking now what the Carloway Fiscals research was based on. Was it the English system where there was no corroboration?
I think it was the English system, wasn't it?
Well, can I ask on that, were either of the two prosecutors, did they have any experience of the English system?
No, I don't think they did have experience of the English system, but they've got experience.
In your opinion, then, would it...
Okay. And then you can come back in, yes, Lord.
Certainly.
But they have experience as a prosecutor, many years' experience as a prosecutor, so they know how to apply a test, they know how to assess the evidence, they know how to look for evidence in support of an allegation, evidence against an allegation, and they know how to apply the public interest test.
Wouldn't a better way to have done it be to pass these cases over to prosecutors who were au fait with the English system and the experience of it and get their opinion? And similarly with the exercise you've just carried out, where you're looking at Wales, you're looking at Northern Ireland, you're looking at, wouldn't it have been better to pass these cases over to these jurisdictions and let them come back with independent and objective analysis from their experience, which must be better than taking the Scottish experience and trying to say, oh, well, we think this would have made a difference? Would that not have been a better way and more conclusive evidence?
No, I don't think it would. I mean, it's possible you could have done that. You could have sent the cases to CPS prosecutors. There's no doubt that could have been done. I would answer your question this way. This was very experienced prosecutors with years' experience. They know how to apply a test. They know how to analyse a case. They know what to look for. So I don't think that had it been passed, for example, to prosecutors down south, that the results would have been any different.
I beg to differ on that one. Lord Advocate, you are the Lord Advocate for the whole criminal justice system, for every accused. Today we've heard very startling, compelling and welcome evidence, I think, that there are unintended consequences from the abolition of corroboration. Today your remarks have been just about totally concentrated on the victims of sexual crimes. What about the other victims and the unintended consequences there? And my question to you is this. Given the weight of concern, given the Lord Advocate's comments this morning, given corroboration, Lord Gill's evidence this morning, given corroboration hasn't just stood still, it's changed over the years. We've got the wisdom of the institutional writers, we've got court practice during the years, we've got this coming down and being something, quite frankly, I think we should be proud of in Scotland. Does it give you any pause for thought that perhaps you might be wrong, that there might be another way other than abolishing corroboration that could be looked at to help the victims of sexual abuse and to ensure, paramount, that the accused right to be presumed innocent isn't compromised, we don't have more miscarriages of justice, and that we have a better system for everyone?
Well, look, I'm not saying that I'm always right. I fully accept that other people may have a different view, other people may be right and I'm wrong. I don't know. My view is that I think I'm right. You raise other alternatives, other possibilities. For example, I think Lord Hope was asked in a recent article in the Hollywood magazine whether or not you could relax corroboration for the category of case which I've been talking about, sexual offending, sexual abuse and domestic abuse. His view was that that shouldn't take place. I think Lord Gill was also asked a similar question and he said it wouldn't be appropriate. I agree with their views on that. I've heard you speak about the possibility of developing the law of evidence or corroboration in relation to that. What I would say about that is that we have over the years developed in relation to Murov, for example, in the Murov case itself, 4 years of a gap in time between two allegations was held to be insufficient for the application of the Murov case. Recently had a case where we argued generational abuse and the court applied a gap of about 13 years in applying Murov. We've greater corroborating lesser. We've argued that an attempt corroborates a completed act. So prosecutors, it seems to me, have been pretty creative in legal arguments to try and place cases before the court. But my point is that the law of evidence has a limit. This is a legal requirement. It's evidence of two independent sources, both that the crime was committed and that the accused is a perpetrator, and the crucial facts of the case, and you can never get past that if you have the requirement for corroboration. But just in relation to that, can I just tell you about what the effect of corroboration has? You need to corroborate the taking of buccal swabs from alleged offenders, so it's 2 police officers to take that. You need to corroborate the taking of intimate swabs from a complainer in a rape case, maybe a child, the injuries to the sexual parts. You need to corroborate.
No, I just let Lord Advocate finish this, and then you've plenty of time. Lord Advocate.
You need to corroborate that children, what appear to be the case in child pornography, are actually under the age of 16. That has to be done by 2 witnesses. You need to corroborate your forensic analysis. So 2 forensic scientists are having to speak to the forensic or the results of the forensic examination. Transmission of samples are being required to be corroborated, and it seemed to me that this is completely unnecessary. So that's where I come from.
So we seem to be back to sexual offences again. I'm looking at the whole system, every accused that comes before into the criminal justice system. My question is, would you be prepared to at least look at a third way where corroboration is retained? And we're looking at all aspects of the law of evidence. You've mentioned this need for 2 witnesses. If it comes down to the credibility of a witness, then vulnerable witnesses who at present can give evidence via video link or special measures, the likelihood is they will be required to attend because it's important to judge the credibility. It's all important then. That's perhaps something, a downside to the other things that you say are positive. We're looking at this within the space of, what, a couple of hours this morning? We've spent the time in corroboration in a huge bill. Wouldn't it be more sensible, given the importance of getting this right, to take corroboration out of this bill, to look at a third possibility as well as retention and abolition, the third possibility of retaining and improving, and having a commission to really properly hammer this out so that we're sure that we've been transparent, justice has seemed to be done, and the right answers have been decided upon. 2
points. I think you mentioned evidence, alternative means of giving evidence by, for example, CCTV, and the effect the abolition of corroboration may have on that. They're required to, rather than give evidence by a remote site, they have to come to court to give evidence. And you used the example about, assessing, a witness by seeing them. I don't think that giving evidence by CCTV or remote link in any way affects the assessment of credibility and reliability. And I don't think, in my humble opinion, that should be or would be the effect of the abolition of corroboration. To go back to your principal question about, another way, another more detailed look at it, you may have in mind a Royal Commission, or the SLC may look at it. Look, I've heard all the views. I respect all your views. Ultimately, that decision is one for the Scottish Parliament, not for me. I'm only giving you my own view on it. I don't think, given the extent of the work done by Lord Carloway in his review, that it's necessary.
Can I just say one further thing? Given the pressure on budgets and Police Scotland and various people, can you micromanage the kind of situation that Lord Gill said could very possibly happen, where if you don't need to establish corroboration, you don't go that extra mile to incur the costs of looking for that corroboration, and the effect of that in unsuccessful convictions?
Well, I'd answer it this way. I think I touched on it in my opening remarks. The police are under a common law duty to fully investigate a case. The case of Smith sets that out, their duties. We are under, as prosecutors and police, under a duty in the European Convention of Human Rights to properly and fully investigate cases and bring forward all relevant evidence. We're also under a duty on our disclosure obligations to make sure that cases are properly investigated, and any evidence which is in favour of or adverse to an accused person is properly disclosed. Prosecutors are under duties to place, make sure that the trial is conducted fairly. The notion that you wouldn't want to bring the strongest case that you could to court is something which is alien to me. But one other point is that the work done by police and prosecutors can sometimes result in an accused person being exonerated, not being taken to court, and that is perhaps sometimes overlooked. And I have plenty of examples of good investigative work carried out by the police and procurators fiscal resulting in no prosecution at all. I can give you a very serious example of that way back in the early 2000s, where a number of people were accused of terrorist offences in Scotland. They'd been arrested living in a flat in Easter Road. It was just before the Hogmanay celebrations in Edinburgh, and it was very sinister exhibits which have been found in this flat. One which looked like a diagram of where you would place a bomb in Jenner's and the Edinburgh Woolen Mill in Princes Street. I know for a fact that the police, with support from the Procurator Fiscal, traced all the occupants of that flat, including one to Perth, Australia, and he was spoken to and he said, yeah, that's my work. I work for Glenmorangie Whisky Company, and actually I prepared that diagram, and that was where I was having a whisky display in Jenner's and Edinburgh Woolen Mill. And as a result of that investigation, the case went nowhere and quite properly wasn't taken up. And that, what I'm saying is that's just an example of the determination, the I suppose, the morality, the right thing to do to fully investigate a case which could exonerate someone accused of very, very serious offences. What I'm saying to answer your question direct is no, not under my watch, and I suspect not under any future Lord Advocates or Chief Constables of Scotland. You'd always want to bring the best case that you can to court.
But the point being, you can't micromanage every case.
Well, I mean,
and there will be pressures. There is no doubt about that. We know there will be pressures. And if you don't need corroboration, then I rest my case.
She's rested her case. That's good, because I've got other people waiting to ask a question. But you did raise examples of where it would appear to me and perhaps other members of the committee that corroboration is over the top when you need 2 police officers to speak to something or whatever. Is there not a way that under a review procedure of this we could look at the requirement for corroboration in those particular instances to be dispensed with unless challenged? I mean, I'm not an expert, but it does seem that you've made a fair case there that that's too much. But we haven't been able to look at that, and I suspect that Lord Carloway didn't have time to look at that because it's getting rid of corroboration across the piece. Instead of looking at that in particular, would that not form part? Could that not be useful to perform part of some kind of review?
Well, it may be useful.
In the whole of the evidence.
I don't demur from that suggestion, but of course at the time that you're carrying out this work, corroborating the taking of samples, you don't know at that time whether or not you're going to require to lead corroborated evidence. I'll give you an example. Say in a homicide, you have to identify the body. So the way it happens in Scotland is family members are having to attend at a mortuary and thankfully look at a screen and identify their loved one prior to a post-mortem examination. Nothing could be more horrendous, I would suggest, than having to do that. It has to be corroborated. In the Criminal Procedure Scotland Act, it says that if you don't challenge the identification of the deceased referred to in the post-mortem report within 6 days of the trial, then that evidence is presumed and you don't need to lead the evidence of identification. But of course, at the time that you're requiring the identification, you don't know whether or not there's going to be a challenge 6 days from the trial. So police officers in those circumstances will require a double identification to comply with the rule for corroboration. Yes, it could be looked at. It could be looked at. Again, what I'm doing is I'm giving you examples of in practice.
It's very helpful, but having raised the issue of that, we've moved from corroborating evidence in court, say, to what's corroborated in gathering evidence and transferring and transmitting evidence, moving it from one place to another. And I think I simply wanted you to follow up and see whether that could form part of any review of looking into what does require and what doesn't require corroboration in court.
Well, of course
That's really
it could. Of course it could.
Thank you, thank you. Sandra, John Finney, Roderick, please.
Thank you very much, Convener. Good morning. I was going to ask you about the requirements and the technical burdens, but you've already answered that particular question. I've no doubt around this table we all want to see justice for victims. We may go about it in a different way, but I've no doubt we do definitely. Certainly, yes, you're looking at the court, cases, etc., prosecution, defence, but we've got to remember under this there are victims who do want access to justice. And I do, 2,803 domestic abuse and 170, rape cases, not even, going to court, basically. That, to me, is a dereliction of justice for the victims that's there. And when you look at the points that's been brought up of the statistics by Ms Dalrymple, you're talking about 1%, 7% increase in these would go to court. And I think it's something that we would all welcome. It's how we get to that particular point, as you say, in regards to corroboration. Now, obviously Lord Gill had given his evidence and very much of the view that we shouldn't get rid of corroboration, very much opposed, but it was mostly the judiciary which was opposed to it. I mean, I broached the question regarding guidelines, and basically we're looking at the Criminal Justice Bill in the round. Lord Gill seemed to say that obviously corroboration should come out of that, and other aspects of the Criminal Justice Bill should be looked at again, not proven and that type of thing. I just wanted, your comments on Lord Gill's comments in regards to that, his opening remarks to that, and also the fact that whilst we've had, members here talk about evidence going forward to prosecution, and judges, as Elaine had, not judges, as Elaine had mentioned about juries, I would just ask what your comment would be, and if corroboration is abolished and more of these cases go to court and access to justice is opened up through time, through time of more cases going through juries, then their attitude may change, or social attitude may change, and we would see more justice done for victims.
Well, I think that's a very good point, and social attitudes do change over time. I mean, I frequently give the example of the social attitude to drink driving in the 1960s in comparison to what it is now, racial abuse in the 70s in comparison to what it is now. There have been studies across the world into what we call jury myths about how jurors across the world see and view certain evidence, such as delayed reporting, such as a lack of physical resistance, such as the way a woman is dressed. That is something which prosecutors and police have to recognise, and hopefully through time that the public, or some members of the public, because I'm not saying that all members of the public subscribe to that, but there's a proportion, some members of the public may change their attitudes, and I think that would be a good thing. We recognise that. I think I mentioned earlier that we do, in certain cases, lead expert evidence to say that, for example, delayed reporting is normative behaviour, and I think that's a good thing.
Chair, could I?
Of course.
Well, thank you very much.
The only thing I'd say is bear in mind we've got another, I don't want to curtail this, and I'm certainly having the other people who are down to ask questions, but that we've got another panel and they have to be away by 12:45, and just alert you to that. So
thank you
for
very
short
much.
questions if possible.
Yeah. Thank you very much, Chair. The other question I was going to ask was obviously the corroborative evidence, and this is what it all comes down to. And I did ask Lord Gill regarding that, and he mentioned about the prosecution. But I would also say in regards to the defence, if you have a case and there's two witnesses, it could be someone's friend on behalf of the defence, not necessarily on behalf of the victim. They may not be telling the truth. So you still have these two witnesses. And if you've only got the two people there and you have corroborative evidence, you've made it quite plain that the police and your procurator fiscals do their utmost to get that evidence. What I'm saying is, and I'm probably wrong in this, and I'm not accusing anyone of this at all, but on the defence side, is it more likely that the defence, the accused, wouldn't necessarily push so hard for the case to go ahead because there was only two people there, without looking at the actual corroborative evidence which could be obtained? I'm not talking about the prosecution of the victim. I'm talking about the accused.
I'm completely lost.
Maybe everybody's lost, but in my head,
I'm completely lost. I didn't
well, let me answer it this way.
You're not lost. That's good, because I didn't understand the question, I'll be frank.
I'm talking from the victim's point of view.
Well, I'll answer it from the accused point of view. You don't need, accused is not required to corroborate anything. Well, and that's a rule of law, and it's a good rule of law. So, I don't have a problem with that. And let me say that in relation to defence counsel, solicitors, I think they do a very good job in Scotland. And in order to have a fair trial process, it requires counsel, solicitors to be at the top of their game to challenge the evidence and test the evidence. In my experience, in many years in the criminal justice system, is that happens, and that's part of the suite of protections to ensure a fair trial, that you have legal representation and that you have robust testing of the evidence. You have the ability of the defence to carry out their own investigations, to lead their own witnesses if they want, to make a statement during interview if they want on legal advice, and whether or not they wish to give evidence. That's a part of the suite of legal protections. There's many more. So to answer your question, you don't need to corroborate anything. That's a fundamental rule of law in Scotland.
John Finney.
Lord Advocate, you alluded to the Cadder case And if I noted you correctly, you said you weren't critical of the Cadder case. You also outlined for us that as a result of that, that one of the 3 essential requirements to corroborate, namely that penetration, is lost. It's been suggested by a number of people that the removal of corroboration is a rebalancing of Cadder. Would you like to comment on that, and is that your particular view or the rationale for your support for it?
Yes, I believe that, and it's not only my view, it's Lord Rogers' view, and he was one of the justices, Supreme Court justices in Cadder, and if you read his judgment, he said that he recognised that as a result of the Cadder judgment, the balance would be tilted against the police and prosecution, and the implication of that being that there may need to be a rebalancing of that to ensure justice to both the victim and justice to the accused, because any criminal justice system is a balance. It's checks and balances to ensure that the guilty are convicted and the innocent are acquitted. And part of the argument in Cadder was that there was a whole suite of balances which included corroboration, and against that you had no right of access to solicitors. So it was a delicate balance. And as soon as you disturb that and make a right of access to a solicitor, then you're disturbing that delicate balance, and there would need to be a rebalancing exercise. So I agree with Lord Roger in that. I've got the utmost respect for him. I worked for him for many years. So that's, I agree with it.
We've heard a lot of use of the term the public interest. Could you rank for me, in terms of 1, 2, 3, the accused's interest, the public interest and the victim's interest? And I've listed them alphabetically for the avoidance of any.
I don't think it's a league table, really. I think that they're all sort of part of the consideration of the public interest. I mean, I'll give you a very extreme example of where how you would determine the public interest. Say, for example, you have a woman, a widow, who's recently lost her husband. She's 65. She's never been in trouble before in her life, and suddenly she's in, Asda, and she shoplifts, and it's a cry for help more than anything. Now, I would suggest that even if it's a rock-solid evidential case, which, if you place before a court, would be bound to result in a conviction, it would be in the public interest, having regard to the accused's interest overall and the nature of the crime. It wouldn't be in the public interest to prosecute that woman. So it's all those kind of considerations that are in the mix.
I appreciate at the margins of extremity either end you can come up with examples. With a standard circumstance of an uncorroborated allegation of crime, of rape or a sexual offence, where would the ranking go in that instance, please?
Well, I don't think there would be, in the sense of a ranking. I think it would be all part of the consideration. I mean, if you're talking about a charge of rape and you had sufficient credible and reliable evidence to place that case before a jury, given the seriousness of it, I think it would be inevitable that you would take proceedings, because it would be in the public interest to take proceedings.
You've already acknowledged there is a rebalancing as regards the accused. The accused, as a result of Cadder, has entitlement to solicitor, which will normally result in them not saying something which would have provided some of the evidence which would have supported you prosecuting in the past. You're saying that's now removed.
So let me answer it with, or try and answer it with the circumstances of a woman who delays reporting counterintuitive behaviour. So there's no forensic opportunities to corroborate.
Example one in your case there.
Yeah. But there's supporting evidence. There's very recent distress. There's powerful recent distress. It may be she says that her pants were ripped, and lo and behold, she's retained her pants. They are ripped, and you have forensic evidence to say, for example, that that is consistent with her account. You can never fill in the gap there, because there wouldn't be corroboration of penetration. So no matter what the quality and quantity of the supporting evidence was in those circumstances, you would never have sufficient evidence to take up the allegation of rape.
So where, apart from a suggestion from the accused that it was a consensual act, would your corroboration of penetration ordinarily come from then?
Well, it would ordinarily come from the forensic evidence if you had that opportunity. If not, then it would be very difficult. In most cases, I would suggest to obtain corroboration. It may be, for example, that...
Example 1, for instance, is a statement of a fact rather than a summary of the outcome of the particular set of circumstances narrated there.
Sorry, I don't appreciate the point.
Right, okay. Well, if I tell you that the outcome is, as there is no corroboration of penetration, we cannot prosecute the charge of rape.
That's the case.
That's a statement of fact in any case.
Yes, but what I'm saying is if you abolish corroboration, there's supporting evidence there that would require you to take up that case. And then it's a matter for the jury and whether or not, having tested that evidence, the jury find that that case is proved beyond reasonable doubt. So that's an example of a case where we can't take up at present with the rule requiring corroboration. But if you abolish corroboration, it's a type of case which we would take up because there's supporting evidence of the complainant's account.
The information outlined there doesn't say whether there was a medical examination, a delayed medical examination, for instance.
Well, delayed medical examination wouldn't give you the evidence to identify or corroborate the identification of the perpetrator.
Right, okay, we'll move on. When you talk about the reasonable prospects of conviction, in the written evidence you give us, you cite a Canadian case, Boucher, perhaps, versus the Queen, 1954, which says, it cannot be overemphasised that the purpose of a criminal prosecution is not to obtain a conviction. Does that conflict with anything you've said before, namely that you would only proceed if there's a reasonable prospect of conviction?
No, I don't think it is. Look, if a person is innocent, I want him to be found innocent. I don't want a miscarriage of justice. I don't want someone wrongly convicted. In assessing whether or not there's a reasonable prospect of conviction, that's the gateway test. And what you're doing is you're using that to determine whether or not the case is to be indicted. So in those circumstances, the case is put before the court, properly tested, and ultimately it's for the jury. What I'm saying is that the requirement for corroboration has an effect because the gates are shut for many victims of rape, sexual abuse and domestic abuse and other crimes, predominantly those categories of criminal offender.
Thank you. Lord Irvine, can I ask you about false allegations? Because, again, in your written evidence, you provide what would be very reassuring commentary if you were a police officer, a teacher, a social worker, a health professional or a prison officer, and that is about the depth of scrutiny that goes in about false accusations. What if you were a joiner, a van driver, a shop worker, an unemployed youth?
Well, I think, to answer your question, there's a recognition that, I suppose, teachers, professionals in those circumstances, including police officers, in a perhaps more vulnerable position in relation to false allegations, and that has to be recognised. So there's procedures in place currently for example, allegations against teachers before a decision can be taken whether or not to prosecute has to be referred to Crown Counsel, so that there's a thorough look at the case itself. And that's the same with police officers itself. But I would like to think that procurators fiscal throughout the country apply their common sense. They're trained, they can analyse a case, they can look at the evidence, they can look for any indications of false allegation, and I suppose ultimately at the end of the day this evidence will be rigorously tested before a court of law if proceedings are raised. And that is the same for a joiner as it is for a teacher, as it is for a police officer.
Don't look concerned, John. What I'm going to say is, because we must move on to the next item, I'm going to allow, I've discussed, we have an opportunity if required. I'm going to get Roddy in because he's sat there waiting, but MD who's not been in.
Included anyway.
That's excellent, but just don't want MD to worry that I'm curtailing this, because it's very, very important analysis of it that we may at some point, Lord Advocate, invite you back if we've got other questions. The same might be true of Lord Gill or other witnesses in this particular issue. So don't feel that I'm suppressing debate on this and questions, but I do want to have the last question from Roderick. Alison, I know you're in the list, but we can come back to things if that's all right. Roderick.
Morning, Lord Advocate. I'd just like to follow through on the differences the new prosecutorial tests will make as opposed to the existing test. Obviously, I've read your submission, paragraph 15. In terms of the qualitative assessment, could you just clarify the difference the new test will make as opposed to current practice?
Well, current practice doesn't have this test, so we'll be applying this test across all consideration of criminal allegations. Currently, we have really there's a focus, in my view, an undue focus on quantity, because if you're looking at a case, and the first thing you look at, really your primary focus is on quantity. Is there corroborated evidence? If the answer to that is yes, currently we'll then look at credibility and reliability, but there's no test of reasonable prospect of conviction which is applied currently by prosecutors. And what I'm saying, to try and give reassurance to the committee and the Parliament, if it is the Parliament's choice to abolish corroboration, that we will apply a reasonable prospect of conviction test where there is supporting evidence for an allegation, and I hope that that would give reassurance to this committee and the Parliament also.
Yeah, but just to clarify, currently may not be a formal test, but you do consider credibility and reliability.
We do, but we don't consider it against a test, reasonable prospect of conviction.
Okay, just about with you, I think. Distress is a comparatively, the evidence of victims' distress is a comparatively recent addition to the corroboration tool. Could you just explain to the committee some of the difficulties that gives rise to?
What evidential value recent distress has?
And explain well, obviously that's an addition to kind of corroboration as it was in kind of centuries gone by, and how that operates in practice and the difficulties it causes.
Well, recent distress is obviously a piece of evidence, but in relation to what it corroborates, in a non-forced rape, it only corroborates the lack of consent. It doesn't corroborate penetration, doesn't corroborate mens rea. So it'll only take you some distance along the three crucial facts that you have to consider, or you have to corroborate in a charge of rape. And of course, there's conditions to distress. It has to be recent. It's got to be displayed to the first natural confidant. You know, there's a raft of case law as to the gap in time between the allegation and when it's displayed as to whether it can be taken account of by the jury. But just going back to the example, I suppose the effect of it is it doesn't corroborate penetration. It can't be used for that effect.
It's helpful. My final point in view of the time is just in relation to the two submissions from the Crown. There's no comment on kind of what might be described as safeguards if corroboration is removed. Is that because you didn't want to get drawn into that debate, or?
Yes, in the sense that, yeah, for example, a not proven verdict, whether or not that should be abolished, I think that's the Scottish Government's announced that's going to be looked at by the Scottish Law Commission, so I welcome that. Don't have a problem with that. There are many safeguards in the trial process. I've alluded to some of them today. I suppose I didn't think we were being asked about that particular additional safeguards. But if it's something that the committee wishes further information on, we can respond in writing.
I'm quite interested in it, but in view of the time, I'm quite happy to leave it there for the moment.
You can write and follow it up. That would be very helpful. Yeah. I'm going to bring this session to an end simply as we must go on to other business. I thank you very much for your evidence, Lord Advocate and Ms Dalrymple, and I'll suspend for 5 minutes to allow the tables to be set up for, it is cool in here, to be set up for a round table. Hot soup, please. Suspend. Very much, and this is us back in, and we get to sit back a bit because this is a round table. So really the format is that we don't ask the question so much as maybe throw a question into the pot, and then we let you debate the ins and outs, the do's and the don'ts, the yeses and the no's for reform of prison visiting committees. And I thought it would be a good thing to start if I just simply ask witnesses to say who they are. Well, we can see it anyway, but who they represent. So, Mr Coyle.
I don't represent anyone, but was asked by the Scottish Government to carry out a review of independent monitoring of prisons.
Professor Coyle, yes.
And hello, I'm David Strang, the Chief Inspector of Prisons for Scotland, a post I took up in June of this year. And as you'll see from the order, the responsibility for the oversight of independent prison monitors will fall to my post.
Next, please. Mr.
Diego Quiroz.
Quiroz. Oh, I like saying that. Right.
Good morning, and thank you for the invitation. Diego Quiroz, Scottish Human Rights Commission.
Thank you very much.
Hello, Lisa Mackenzie, Policy and Public Affairs Manager at Howrey, Scotland, and a very last-minute substitute for John Scott, our chair, who is very sorry he can't be here, but family member who's in hospital. So
I'm sure you'll be brilliant.
Joan Fraser from the Association of Visiting Committees and a member of the Polmont Visiting Committee.
Now, who wants to start? Just throw a question into the pot. Okay. Elaine, you do that, and then we'll...
I noticed in the submission from Professor Andrew Coyle, who was actually commissioned by the Scottish Government to undertake a review of this, that, Professor Coyle, that you do not feel that the Government actually accepted your recommendations, and you have some quite significant concerns about the proposals in the instrument. I wondered if you would like to say a little bit more about the work you were asked to do and the response of the Government in respect to that.
Thank you for that opportunity. My terms of reference were to review the extent to which the Scottish Government's then proposals were in conformity with the Government's obligations under the optional protocol to the Convention Against Torture. So at one level, they're quite narrow terms of reference. But I agreed with the Cabinet Secretary that I could interpret them fairly broadly. The reason that he asked me to do that was because in respect of the current arrangements for independent monitoring, which is done through visiting committees, that does not conform with OPCAT. Now, it's important to understand that the reason that it doesn't conform with OPCAT is solely because the budget for their work is with the SPS. It's not any judgment on the independent monitoring which they do. It's solely on the fact that their budget was with the SPS. What the draft order now does is take control of that budget away from the Prison Service and gives it to the Chief Inspector of Prisons. And since that was the bar to conformity, then it is true to say that the new arrangements will satisfy the minimum arrangements for OPCAT, and that's to be welcomed. However, if I may make a couple of brief remarks, there is a difference between the irregular cyclical inspections, which are done every 3 or 4 years by the Inspector of Prisons, and the regular continuous monitoring, which is done at the moment by visiting committees, but done by independent monitors. And that distinction is important and should not be confused. The Cabinet Secretary has talked about in his forward to response to my review that he wants Scotland to have a gold standard for the oversight of prisons. And I think it would be, as it stands, the order doesn't achieve that gold standard. It would be possible to do so, I think, with some relatively straightforward amendments. The first would be to remove the distinction between prison monitors and lay monitors. That's a distinction which wasn't in my review. I have no knowledge as to where it came from, and I think it muddies the water and creates a new tier of bureaucracy which is unnecessary. All we need, I think, is a single tier of independent monitors for each prison. The second tweak to the order would be to replace what currently is a power of the Chief Inspector to instruct monitors. I think that's an unhelpful description, and to replace that with a requirement for the Inspector and the monitors to cooperate in their work. And if those two changes were introduced, then I think the order would be significantly improved. One last opening comment, if I may. Under the current arrangements, visiting committees are not part of the UK National Preventive Mechanism, unlike the two partner bodies in England and Wales and in Northern Ireland. The irony is that this exclusion is likely to continue under the present order, because the independent monitors will be represented by the Chief Inspector. They, unlike their colleagues in the two other jurisdictions, will not have a place at that table.
I'm going to bring in Mr. What you do is just let me know, indicate to the clerk here if you want to come in, Mr. Quiroz. And yes, I was going to bring him, but because Mr. Quiroz put his hand up first, so I'll bring you in first, please.
Thank you, Convener. Can I start here by clarifying 3 points that the Commission wants to put forward to the committee in 3 interlinked points which are quite relevant. The first one relates to OPCAT. The second one are the minimal requirements that OPCAT asks the state party to comply with. And the third is the proposed draft order. The optional protocol, as you know, as you are aware, is an international human rights instrument that aims to the prevention of torture by establishing a system of regular visits to places of detention. This is to be undertaken by both independent experts at both levels, national through the NPM and international through the SPT, the Subcommittee to the Prevention of Torture. My first point here is that there is a state obligation to be taken seriously. The second is that OPCAT does not dictate what form these mechanisms should take. And indeed, in the UK, the NPM has taken quite a variety, a different form, because there are 18 different bodies that conform the NPM. In terms of prisons, as Professor Cole said, he has taken the form of independent monitoring boards in the rest of the UK, in Northern Ireland, England, and Wales. We have chosen a different model, and that's okay. However, what is clear is that the new structure must comply with the minimum guarantees set out in OPCAT, and those are the body's mandate and power, appointment process and staff for members, financial autonomy and funding, and the lines of accountability that ensures operational independence. Now, the proposed draft order is silent in most of these issues, or explore them partially. So the Commission considers that the proposed order could be improved by creating a clear and comprehensive legal framework that enables monitors and the Chief Inspector to conduct the function. 2, to provide greater legal certainty to the system. And 3, to ensure confidence in the system.
Thank you very much. I welcome Graham Pearson, who apparently can't just leave us alone. You're missing us so much.
Fascinating up here.
Aren't we just wonderful? Mr. Strang.
Thanks very much indeed. Perhaps I can begin by just saying a comment about the importance of the scrutiny of places of detention. Often our most vulnerable citizens are in prison, and they're put there by the state after due process. And I think it's hugely important that there is independent scrutiny of how prisoners are cared for, their treatment in prison, their conditions in prison. And that's why in Scotland we have an independent inspectorate of prisons, and the Chief Inspector's post, which I hold, And it was stressed to me on appointment that this is independent. So it's independent of the government, it's independent of the Scottish Prison Service, and I can go in and visit and inspect anywhere in a Scottish prison. And the point about monitoring, and Diego has mentioned this about the requirement for the National Preventive Mechanism, is that there should be monitoring and being done by lay local people and inspecting as two separate functions, but clearly connected. And I know that Andrew Coyle makes the point in his report that they are complementary activities. They're separate because clearly inspection is done infrequently, and the inspectorate go and do a kind of deep inspection of every area of a prison, a team of 10 for 10 days, and then a report. And that's an infrequent, maybe happens every 2 or 3 years in a particular establishment. Monitoring is something that is done continuously. So there are people from the local community who go in and monitor. They speak to prisoners, they speak to staff, and they report to the Governor, and they report annually to the Cabinet Secretary for Justice. But it is a continuous process. But it is, if you like, an outsider going into a place of detention, forming a view, and I suppose reassuring all of us as citizens that our prisons are properly run, or if there are grievances, that those can be taken up. Now, what this order does on the new arrangements, and I think I've read through all the submissions that you've had, they're broadly welcomed in putting more of a structure around the independent prison monitoring bit. There's little in the way of change to the inspecting bit, but the independent monitoring, as you know, up to now, has been done by visiting committees attached to each establishment. But I think what has been recommended and was recommended in a review of the visiting committees 8 years ago was about greater coordination, better training, recruitment, and so on. And I think that what these arrangements will allow is the two sides of scrutiny to be better coordinated. So I absolutely support the independence of the prison monitoring. The language we've been using is about independent prison monitoring. They will continue to monitor independently, but with what are called in the order prison monitors, so the paid monitors, they will perform a function of, I suppose on my behalf, assisting with recruitment, training, appraisal, coordination, and so on. And for that, they will be paid, but they will be monitors. So they themselves will be expected to go into prisons and so on. So the order creates those within the world of independent prison monitoring, the kind of two levels. There are what are called the lay, so the, if you like, the local volunteers that very much reflects what the current visiting committee members do, and then the paid coordinators who are called prison monitors. And I think, just briefly to answer Diego's 4 points about the arrangements being about independent, they are appointed for a time. Their funding is now not going to be through the prison service, and they're accountable, I suppose, through the inspectorate, which in itself is an independent body. And I mean, there are lots of things that are not in the order, and I'm told that this is a kind of legal technicality, that you don't want to put too much detail into things like what the selection process will be, what the training package will be. I had a comment that you'll have seen in mine that I was surprised, disappointed that the advisory group, which is to be established, is not required in the order. But I mean, all of these things will be part of the implementation when the order, if the order is passed.
What you've not dealt with is this business of the distinction, the separation between your role and what prison visiting committees did, because as I noted, you have powers to instruct monitors and monitors to instruct lay monitors. And I think that's a key thing in Professor Coyle's submission, which you didn't touch on, so if you perhaps develop that, then I've got Ms Fraser to come in next. Oh no, I know I've got Ms Fraser first. She's not been in. Sorry.
I thought in my opening comments I had made very clear that there is a distinction, that inspecting is one thing, and independent monitoring is something different, and I see that those two are separate. And what the new order does, I suppose, is give my office, me personally, new responsibility, not just to head the inspectorate, but to oversee and be responsible for independent prison monitoring, and that is through coordination. And I see that that is done through the paid prison monitors. Now, I know in legal terms it says instruct, instruct, but I'm not anticipating that I'm going to be wagging my finger and say you will, and that they will wag their finger and say will. I mean, I don't disagree with Andrew Coyle's comment about a duty to cooperate and work together, because that is very much the style of how it must work. If it's going to be successful, it needs to be cooperative. The prison monitors need to support. But I suppose the other bit of it, and one of the criticisms of visiting committees in reports I've read, is that they are, they're almost too independent. Now, I don't mean that in a principal sense, but they're off doing different things, so they're not coordinated. Their reports are quite different. And so I think if we're going to get the best from monitoring and the best from inspecting, then I think there needs to be some coordination of that. And that is a duty that will fall to the paid monitors. They will report to me as the Chief Inspector. So in legal terms, yes, I can instruct them, and yes, they can instruct monitors, but it is much more about coordination, making sure there's good communication. So if a set of monitors find things in a prison, that can be communicated to the inspector. We might, for instance, do a thematic inspection as a result of what monitors have found. So I don't see it quite as hierarchical as, I mean, I know that it reads in a very hierarchical way in the order, but I think that's a legal point. In terms of the implementation of how it will be managed, I think it will be much more cooperative.
Trouble is, instruct's the word that's there.
Indeed, indeed. I don't deny that, and that's told for legal reasons.
I have, and we'll come back to that perhaps, and if you want, might come back, Professor Coyle. Ms Fraser, you want to come in, then I've got Mr Quiros. I'm getting it wrong already. Am I not all right? Okay.
I think what's actually in the order is absolutely crucial. As far as the so-called lay monitors are concerned, all it says about their duties is that they will assist a paid monitor, which on an extreme view might be carrying their briefcase, or it could be the full range of monitoring duties, but that's absolutely unspecified, and that they must comply with instructions, which to me is not independent. They could be instructed not to do certain things because it might be awkward or embarrassing. And I'm not suggesting that the current Chief Inspector has any intention of doing any such thing, but this needs to be future-proofed and person-proofed. So we do not know that in 5, 10, 20 years' time, a Chief Inspector might say something that all of us round this table would feel was actually fettering the independence of independent monitors. The legislation is, as I say, completely silent on the role of the lay monitors. The role of the paid monitors is described in some detail, but all of the protections that would come from having a proper, transparent and effective appointment system, conditions under which monitors could be dismissed, all that kind of thing that would produce a robust and independent system is completely absent from the order, and we're to rely on guidance, which can be altered without ever coming back to Parliament. I'd just like also to say something about the hierarchical nature of the paid monitors and the lay monitors and the Chief Inspector and an advisory group. It's very complicated. My question would be, what is it that the paid monitors are going to add? Where is the added value? If we have somebody who can coordinate, who can support, who can provide training, which at the moment visiting committees have to do themselves from their own free time given by members. If we have all that, that is absolutely fantastic, but the role of that person should be made explicit in the legislation and not a role which is a monitoring and oversight and almost a fettering role as the legislation is described at the moment.
I'll take Mr Quiros first and I'll come back to Mr Strang.
A couple of points there. The Commission considers that human rights standards should be on the face of the legislation. Human rights standards applies in all circumstances and all times. So I totally agree with Ms. Fraser about the point that legislation should be as future-proof as possible. So we need to build a system that serves not today's circumstances, but also unknown circumstances. And I have not any single doubt about the personal integrity and professionalism of the Chief Inspector that I had the pleasure to meet a couple of times. But it's beyond that. It's about building the best system, the golden standard, as it was mentioned before, for monitoring of prisons. The second point is the technical nature of secondary legislation is to be specific. So there is nothing wrong to contain all the elements that we mentioned before. Can I give just a brief example here? I'm also an independent expert on human rights institutions for the European Commission, and during my missions to European states that are applying for EU membership, i.e., well, I won't mention the states, but what we do is that to ensure that those applicants state complying with EU values, i.e. human rights, the rule of law, and democracy, the so-called EU acquis. When I travel, I take just a copy of a piece of legislation that was drafted and enacted by this Parliament, the Scottish Commission for Human Rights Act 2006. And when governments of those applicant states ask me how legislation should look like in terms of establishing a national human rights institution, I just show them. This is a golden standard. This is the best-in-class legislation. The legislation contains a detailed account of the powers and mandates, the annual reports, the immunities and privileges, membership, independence, disqualifications, terms of office, staff, sources and nature of the funding, accounts and audit. So it is possible to have all that in a piece of legislation. And why not to replicate this in the area that we are talking about? So to have a legal framework, and this means to be specific, would guarantee both the independence and the effectiveness of the new structure for today, but also for tomorrow.
Thank you. Yes, of course. And then
Thanks very much. I mean, I don't know if it's an either or it's an and. I mean, I think all the principles.
Vindicated.
Well, I'm very grateful to Mr. Kouros for that. But I mean, I think all the points that Diego makes about that should be a feature of it, I think we will include in the implementation. It's just it's not in the face of the order. And I just wanted to respond really to Joan Fraser's comment about the lack of definition of the lay monitor's role. And I can understand where that comes from, because I mean, I don't know if you have the order in front of you, but Section 7A, which lays out what the paid monitors do, is very clear and specific. And under the lay monitors, it is less specific, but you can get there through 7B3A, which says that they have to assist monitors in carrying out the specific duties mentioned in 7A above. So, I mean, I think it would be clearer if those duties were specified for lay monitors. But I don't think it's as arbitrary as Joan Fraser was suggesting, and because their duty is only to assist a monitor in prison monitoring. So, I mean, the notion that they could be instructed to carry someone's bag, in my mind, is completely outside this. And, you know, part of my duties at 7A1 is to evaluate the performance of paid monitors. Now, if I hear that any paid monitor is instructing a member of the community to carry...
A metaphorical...
I know, but I suppose I am making the point that it is not unfettered and unlimited and arbitrary. Their duty is to assist in the monitoring of prisons, and they are appraised on that by me, and as lay monitors too will be appraised. Thank you.
Just to let Professor Coyle in first, and do you want in as well, Ms Mackenzie? Yes, I'll come in that round. It's fine. Okay.
You've made the point, Convener, that the order does say instruct. There is no way around that. It's very clear that the the order says in terms, the Chief Inspector will instruct the prison monitors will instruct the lay monitors. I mean, that doesn't need to be interpreted. And it equally says that the lay monitors will assist the prison monitors. That's a partnership. That's not an equal partnership. I think if I can make a specific point, having worked for many years in prisons, some people in prisons welcome independent monitoring and some people don't. But I also know that both staff and prisoners need to have clear orders. They need to understand. There needs to be no dubiety, because if there is dubiety, then they will drive a coach and horses through it. And if I could just give you one example of the lack of clarity which results from having these two tiers of monitors, the issue of prisoners' complaints, which is actually quite an important part of the monitoring work. The prison monitors, according to the order, will talk to prisoners, but the lay monitors will take complaints, not the prison monitors, the lay monitors. Now, that's a fine distinction which prisoners are going to find very difficult to cope with. And you would also note, of course, in passing, that in his written submission, the SPSO had a view on complaints because he thinks that he's got a specific role, and indeed he does have a specific role in terms of complaints. So we are going to confuse people, and that's always a bad thing to do in the prison setting.
Thank you. I'll take Ms Mackenzie first and come back to you, Ms Fraser.
Andrew's actually made my point. That's what I was going to say. But, I mean, yes, there's two possibilities with the lack of parity between the duties as set out in the order between the paid and the lay monitors, and the complaints one is the obvious one, and the point that Andrew makes about that being confusing to prisoners is absolutely one that we share. And I think there are two possibilities. One is that this was a genuine oversight, not replicating the duties. Another one is that it's not practical to expect the paid monitors to handle complaints because they're only going to be in the prison fairly infrequently. We're talking about 3 individuals who work part-time. That part-time, that's not clear, but possibly 2.5 days a week covering 16 establishments in Scotland. So it's not practical. One of them goes into Saughton one week and a prisoner says, I'm really concerned about my relationship with my prison officer. I feel like I'm being bullied. And, oh, well, you can't talk to me about that. I can't take up your complaint, but wait till the lay monitor comes in. But that does rather lead us back to the question, well, why have the paid monitors? And it ultimately is just very confusing to prisoners. But I think we concur with Andrew and with the ABC that this is a needless hierarchy. It's an extra layer of bureaucracy and it's not clear what it will achieve. But we completely agree that the Inspectorate with this oversight role does need extra resource. But that resource could be in the form of a couple of members of staff who take a coordinating, supporting role, who help mete out the training programme, who help with the recruitment. Perhaps they do go out and visit prisons in the course of that to support the independent monitors in the community. But really, for us, the big question is what value is there in having paid monitors on such a scant basis?
Are you suggesting you give them a different name, for example?
Well, coordinator or, yes. I mean, it's not a hugely big distinction necessarily, but I certainly agree that on the face of the legislation, it's important.
Ms Fraser.
Sorry, if I could just pick up on that last point. It's not just about changing their title from paid monitor to coordinator, it's actually changing their duties on the face of the order, so that it's quite clear that they're there to ensure the proper operation of independent monitoring by lay monitors. The point I wanted to make was, well, there were two actually. One was about complaints being heard by visiting committees. In fact, what the current legislation says, the prison rules, is requests. And very often what we deal with is not actually a complaint, it's a concern of some kind. It's an area where they're confused, they have tried to get information, the prisoner that is, and has been unable to do so. And of course the other issue is that complaints or requests in direct opposition to the formal internal thing is they can be done orally. So a prisoner can stop you as you're going around the prison and say, can I speak to you? If they're illiterate, which about 80% of the prison population is, they can get a friend to just fill in a form saying, I want to see a member of the visiting committee, and it's confidential. And it gets followed up and resolved within a few days. But it's not just about complaints. So that's a further area of confusion, because if lay monitors are only to deal with complaints, and a prisoner, it's the reverse, it's the mirror image of what Lisa was just discussing. If it turns out to be a search for information or a concern but not a complaint, then as the legislation stands, the lay monitor would have to say, well, I'm sorry, that's not for me. You'll have to wait until the paid monitor comes along. And I don't know when that will be, but it might be next month. The other thing about the paid monitors, whether it's in relation to dealing with complaints or not, is that I am very clear, and I think most of my visiting committee colleagues will be very clear, that prisoners simply won't trust it. They don't trust the inspectorate. With all due respect to David, it's not a personal thing, but they see the inspectorate as part of the bureaucracy. And everything that life has taught them is that the bureaucracy is in the business of doing them down or putting them in prison or whatever. Things that they don't like happen to them when they come up against bureaucracy. They don't see lay monitors like that. Indeed, I think sometimes prisoners question our sanity when they are told that we do this in our own time for no pay. But nevertheless, they do trust the lay monitoring system as it is at the moment. And I think that having a hierarchy, which means that paid monitors oversee the activities of lay monitors, means that prisoners will not trust any of it.
Do you want to come in, Mr. Strang? Now, I've got a list of committee members, but I am going to take witnesses first, so it's not that you're not on my list. And just to let them all know they should be happy, I've got Margaret, Roderick, Graham and Sandra. I have taken a note of the names, but I'm letting the witnesses speak first.
Let me just respond, thank you. I mean, I think what Bill Fraser just articulated is why the role of the lay monitoring is so important, because I think they will be in and out of the prison much more frequently than the paid monitors. So it will be that prisoners will get to know them and will speak to them. I would just... I don't think that 80% of prisoners are illiterate. I mean, some of them are, but I don't think it's as high as that. And I thought the SPSO's comments were interesting ones. I think just on the instructing point, we've had questions about my successor and how they'll behave. I think one of the questions is how will independent monitors behave now? We all hope and expect them to behave well. If the current prison monitor's role is kind of purely a coordination and a voluntary, you can take note of what they say or not, then there's a possibility that some monitors might say, well, we hear what you say, but we're going to do it this way. Now, I think if our ambition here is to ensure consistency and high quality, good recruitment, good training, then I think the way the order is written just gives the authority to monitors to make sure that they have the ability to implement a good system across the country. Thank you.
I'm now going to take... I'll let Margaret, first of all, your question for everybody.
I don't think, regardless of any faults with the current system, then no one ever doubted the independence. I think that's key and crucial here. And particularly with the four paid monitors. Can I ask where this idea came from and what evidence there was to substantiate it's a good idea? And if, as you say, Mr. Strang, it might help you out in your department, wouldn't another way round that be to put the finance into giving you a bit more support within that department without compromising independence by introducing paid monitors who, by virtue of the fact that they are paid, immediately give rise perhaps to suspicion within the prison community from prisoners?
Yes, please, yes. With questions to you, yes.
I mean, it's interesting that you say that their independence wasn't doubted, and I think at a personal integrity level you're absolutely right. But of course, as Andrew Cole said, the reason that they didn't meet the OPCAT compliance was that their funding came through the state provider of the prison. So that there's a Scottish Prison Service that paid them, and for that reason they were then not seen as independent from the prison service. And I suppose the attraction, and I presume, I mean, I wasn't in office at the time, but the attraction, and it was one of Andrew Cole's recommendations, or one of the options was, for where the oversight of prison monitoring should be. There were several options in sport, but one of the options was to the Inspectorate, and that is obviously the one that the Scottish Government has chosen. And the attraction of that is that, despite what some prisoners might think, I mean, the Inspectorate of Prisons is independent. It's independent of the Scottish Prison Service, and it's independent of the Scottish Government, notwithstanding ultimately our funding comes from there. But in terms of inspection reports, they are independent. So I think that's why in the order it says that it is the inspector, the chief inspector, who will provide that oversight and coordination. And it simply seems to me that there needs to be people. I can't personally coordinate 16 groups of prison monitors monitoring 16, or as it will be next year, 15 prisons in Scotland. Therefore, there needs to be people to do it, and this lays out that they will be the prison monitors. They will have those functions, and I know some of you are suggesting that they should be purely kind of administrative, but I think there is a strength to having them as monitors. They will understand. They'll have, I think, because they will legally be prison monitors, they will have the power, as the lay monitors will have, to go into any prison or a prison to which they're assigned at any time, speak to anyone, look at records. I just think they will have I think they'll have a higher level of credibility and a better awareness and knowledge of the whole business of monitoring, which will be their job, because they're in and out of prisons. I think if it's left as a sort of coordination role, sitting in an office in Edinburgh somewhere, I think there's a danger that they'll be too remote and distant from prisons.
Thank you. Professor Connell.
Initially, could I just briefly refer to the budget? The reality is, at the moment, there is no budget. Governors, almost with grace and favour, will pay the expenses of visiting committee members. I say grace and favour because what I discovered when carrying out my review was that there was much inconsistency if governors could either be supportive or not supportive of the work of visiting committees. The total amount expended in the whole of a financial year by the SPS on visiting committees seems to be, no one's very sure, but seems to be about £70,000 in total for all monitoring of prisons. And it's reckoned that local authorities top that up to the tune of about 20%. So that's 90%. Could I answer Ms. Mitchell's question, where did the 3 monitors come from? Because I lived with this for 3 months a year ago. And one of the initial and continuing difficulties I had was to work out the dynamic nature of the Scottish Government's proposals, because they seem to develop over a period of months. The Scottish Government started from a position of abolishing visiting committees and replacing them with an advocacy service. And I won't go through all the details because I'm sure your committee knows this. The government then moved, following debates in the chamber, from a position of abolition to a position of saying there would be 3 paid monitors for the whole country. According to the previous Chief Inspector, when I asked him how this came about, he told me that he was approached by the Scottish Government to say, if you were asked to take this on, how might you arrange it? And he came up with this notion. He said, had he been given a blank sheet of paper, he would have come up with a different model. But he was presented with this. The Parliament had been told there would be 3 paid monitors, and the Chief Inspector was then asked how would he manage that. And so he came up with that proposal. The government then, following consultations in the summer of 2012, moved to 4. The 3 paid monitors initially were the assumption was to be former prison people. It then moved to 4 monitors who would not necessarily be prison people. And by the time I came on the scene last September, October, they had moved on to say it would be 4 monitors plus lay people to assist them. So it's been incremental. There has been no real strategic thought to it. And I thought it was unfortunate. It was quite clear in my report that if there was an appropriate number of lay monitors for each prison, let me stress, then there would be no need for the 4 paid monitors. But I recognised what the previous Chief Inspector had said, that he would need, he said he couldn't support or introduce consistency to this with his present staffing. He would need to increase his staffing. There's no argument about that, and that's for the Chief Inspector to say what that might consist of. The problem we've had is that this has been growing and growing and growing without really much strategy.
I'm going to let other members, I'm bearing in mind I've got to finish at 12:45. Roderick, please.
Yeah, I just wanted to switch the emphasis onto this question of the distinction between inspection and monitoring of prisons being complementary but distinct. Diego, in your submission, you point out that Scotland, if this goes ahead, would be the only part of the UK where they were combined in one body. I just wanted the panel's views on that and how that might work, bearing in mind that you'd suggested a protocol in your report, score which hasn't been taken up.
In the course of my review, I interviewed the Chief Inspector of Prisons for England and Wales. I had discussions with him primarily in his capacity as lead member of the UK National Preventive Mechanism. But we also moved on to his relationship with independent monitors in England and Wales. He made it very clear that he and his predecessors had a much closer relationship with the IMBs, Independent Monitoring Boards in England, than has been the situation up until now in Scotland, and he thought that that was very important. He said that he could foresee a situation if it were, at the moment, they have their own coordinating committee, their own secretariat for the whole country, which deals with recruitment, training, payment, and so on. He said that in these straitened times, he would not necessarily be against his office taking over that part, the secretariat part, but he said he would resist any suggestion that he should actually take over direct authority for the independent monitoring boards because of the fact that he saw these as 2 different functions.
Particularly
Else want to talk about that?
No, I've got somebody ready asked. Mr.
Thank you.
Yes.
Thank you for your question. I think that's a very important point about these 2 distinct mechanisms, and I'm talking about monitoring and inspection. And I think we feel actually that the order is not very, very clear in relation to this distinction, and the order should be explicit about this prerequisite that exists in OPCAD. The SPT 2010 guidelines, which clarify the expectations regarding the establishment of national preventive mechanisms, are very clear that the national preventive mechanism should complement and rather than duplicate or replace the control and inspection functions of the government, as the Chief Inspector mentioned before. So taking together these 2 separate mechanisms, inspection and monitoring provide an effective means of preserving human rights and preventing abuse in prisons. But what is very important here is that in Scotland, the Chief Inspector of Prisons carry out an inspection role by statutory duty. Therefore, it's vital that the monitoring function doesn't get lost or subsumed within the inspection work.
Thank you very much. I mean, I agree wholeheartedly with those comments, and that's why, with my opening comments, I talked about the difference between inspection and monitoring. In the new world, people working in the inspection bit will not be monitoring, and people in the monitoring world will not be inspecting. The risk, if there in two different organisations is that you might get duplication, information being lost, communication not being good. The advantage of having them coordinated and good communication is that information, I mean, it might be that the inspectorate is concerned about a particular issue across Scotland's prisons, so I don't know if there are complaints about healthcare. It could be possible in the regular meetings with monitors to say it might be that monitors should, when they go into their prison, have a particular look at healthcare because that's been raised as an issue across a number of prisons. So I think there's an ability to kind of inform, coordinate, not encroach onto their independence, and they can still go and inspect and or visit and monitor wherever, and vice versa. If in reports coming in from the lay monitors in a number of prisons and they're concerned about quality of food or something like that, then that's something again that could be coordinated across all 15 prisons, so the monitors might all look at that, and similarly it could actually feed into the inspectorate's work. So I'm accepting entirely that there are different functions, but there is real benefit, I think, in having better communication, better coordination of activity in a way that we don't have at the moment.
I think there is quite a lot of reliance in the justification for these changes on the removal of organisational barriers, but absolutely no information about what these organisational barriers are perceived to be. At the moment, when an inspection is carried out, one of the first things that the inspector team do when they go into a prison is set up a meeting with the visiting committee and talk to them about any concerns they have in the prison before the government's involvement in changing the independent monitoring system kind of derailed the process. The Association of Visiting Committees was in the early stages of trying to develop a protocol with the Chief Inspector, because both the visiting committees and the Chief Inspector and the Inspectorate team recognised that we had information that we could probably share a bit better than we did at the moment. And there is absolutely no reason why we can't develop that into a proper protocol, as Andrew Coyle's report suggested. It doesn't need a massive piece of legislation to turn the whole thing upside down to achieve that. Nor does it need legislation, to pick up an earlier point, to change the way that the budget is managed for visiting committees at the moment. That could have been done by the Scottish Government at the stroke of a pen. Doesn't require legislation. It was the Government's choice to make the prison service responsible for the budget or the expenditure of visiting committees.
Thank you. I'm conscious I've got 9 minutes, so I'm going to ask Graham and Sandra to ask their questions, and then I'll just let them be answered. So, Sandra, then I'll take ladies first, if you don't mind, Graham.
Thank you very much.
Short questions.
Thank you very much, Chair. Short questions. Good morning, good afternoon, whatever it may be just now. Obviously, I think everyone has said there is a need for change, and you've said yourself, Ms Fraser, there was a need for change. Could you expand perhaps a wee bit more on the fact that obviously it's got to be OPCAT compliant, as Professor Coyle has mentioned, and this is the issues that's came up. There's two issues in between which I think people are in disagreement about, is paid monitors and basically, exactly what their functions are going to be, basically. If you've not got paid monitors, I heard what the other lady said there about bringing in prison officers, but then I also picked up on some of the stuff you had said yourself, Ms Fraser, regarding prisoners are not inclined to trust.
This is a narrative.
Sorry, well, it's just
I want a question, because I've only got a few minutes.
To trust unpaid monitors. I just say, if you don't have this set up, what set up would you have? Okay.
What would you propose instead?
Sorry,
and
but
Graham.
what would you propose instead? Okay.
Thanks for the luxury of asking the question, Convener. Having given evidence previously, in a previous life, to an OPCAT committee, I think that they feature in four things, as I understand it. First of all, the importance of independence, effectiveness of the arrangements, transparency in the way the arrangements are demonstrated, and regular reporting that the general public can have access. I think that Mr Coyle has outlined the kind of misty history of where we are just now, And rather than being a general support for current proposals, there is a great deal of difference in the approach. Language is important.
Question, please.
Yes.
I mean, really, I've got 5 minutes.
I think this is an important issue, and
It is
that's why I came.
but
OPCAT take a great deal of attention to the language of the legislation. It's interesting that the Section 7B, at subsection 3, they talk about assisting prison monitors as been discussed. But subsection 4, the monitors must comply with the instructions of a prison monitor, but only take account of any guidance from the Chief Inspector. And that element of the absence of discretion on the part of the lay visitor to report in the fullness of how they see it, I think is a really serious issue. And I also think that the conflict of interest that might occur where lay visitors identify issues which have impact for the inspectorate visitors is one that needs to be dealt with.
Discuss is what I say, and you've got exactly 6 minutes. So I'm sorry about this. Sorry? Have I got longer? No, I haven't. No. So I've got 6 minutes. So who wants to pop in here with alternative regime, alternative solution, conflicts of interest? Please just show your hands now. Professor Coyle.
The alternative is on the table, as it were. We are, if the Chief Inspector is going to coordinate and support, then he will need additional resources. And no doubt he will have a view as to what that additional resource consists of. He's quite right to say that it's not just light, it may not be just light touch coordination. There needs to be a degree of ensuring consistency, but it could come from within the inspectorate, and they would be difficult. It's the paid monitors bit that is causing all the problem. In terms of Mr. Pearson's point, as I said in my opening comments, this order does comply with OPCAT because, as Mr. Hiros says, OPCAT is not prescriptive. It doesn't tell a state party what exactly how it should do it. It says what it should do. But the point is we have an opportunity here to make it what the Cabinet Secretaries call a gold standard, and it wouldn't take much to do that.
Thank you. Yes, Ms Mackenzie.
Andrew's mind is running 1 minute ahead of mine, where he's quicker on the buzzer, I'm not sure, but that's more or less what I would have said. I mean, our main point is that we really don't see what the paid monitors add to the equation, but we absolutely agree that the inspectorate must have extra resource, and open to persuasion about exactly what form that might take. But I just wanted to make one very quick point about the link with local communities that we see is really vital, and the fact that these people currently are drawn from local communities. After all, most prisoners in our prisons are going to go back into those communities, so having advocates and people who know what it's like on the inside of the prison walls is absolutely vital, and therefore a continuation of that is really important.
Can I pick up on Professor Coyle's point about OPCAT compliance? Our statutory duty is to identify and promote best standards, best human rights standards. That's what we have done here in our submission and what I'm trying to do right now. So we recommend some specific areas, and again, I'm going back to some human rights concerns that we haven't discussed today because of material time. So the frequency of the visit of lay monitors is not expressed in the draft order, and we think that it needs further consideration. Issues of independence, also issues of membership election process, operational autonomy, security of tenure, and the proposed order is silent about most of these issues, about the use of Paris principles and other human rights standards, which are very, very important in this area. And finally, in relation to immunity and privileges that are necessary for the independent exercise of the function of the monitors, as well as the reprisals. None of them are mentioned in the proposed draft order.
I think that what's proposed in the order is something that is more expensive, less independent and less effective. It's going to cost at least £250,000 a year to run, compared to the 70 or so thousand at the moment, and I do not see what we're getting for that. In terms of what I would like to see, we have repeatedly, the AVC, presented a model to Scottish Government of something which is robust, independent, carried out by lay monitors, connected into the local community, properly supported, properly trained, consistent approach to monitoring. All of these things have been supported by the AVC since the review of 2005, which regrettably was never implemented by the government, despite a commitment to do so. So overall, what we want is something that meets the gold standard of independent monitoring and is not what I see and think many people see this proposal as, which is a sort of grudging compliance with international law and human rights.
Well, you've been pretty firm about that, a grudging compliance. I'm sorry, you've got to be quite quick now.
30 seconds. I mean, I think it is more than grudging compliance, I think, and no one is arguing really for the status quo. And you know, we've had lay visiting to prisons for over 100 years, and this change is about saying we can improve what we're doing with some consistency, coordination, better training. All the list of Diego Quiro's comments about appointment training and so on. Andrew Cole mentioned the Independent Monitoring Board. I was in London last week meeting the head of the Secretariat of the Independent Monitoring Board, and one of his real frustrations was to say that some, he didn't name them, so I can't anyway, but Independent Monitoring Board are off doing their own thing and they take no notice of guidance and instruction that comes out from that office. So I think that's the risk if it is purely advisory and coordination. And I just think this is a neat combining the role of monitoring with providing support and coordination. But as I say, I do not expect instructions to have to be issued. I mean, it is about guidance and it's about how we work together to make sure that our prisons are properly scrutinised.
Done really well. That's just 46 seconds over. Can I say that this is a draft order, of course, so we've got an opportunity to the committee to consider this and report and even ask the bring the Cabinet Secretary's attention. So it is a draft order at the moment. Thank you very much for coming. Thank you very much for your patience. Thank you very much for your accelerated evidence. And that concludes this evidence session, but for the committee it doesn't mean the end of the meeting. So if I could just ask everyone to... Sorry? I'm not finished. The next meeting is Tuesday, 26 November, when we'll continue taking evidence on the Criminal Justice Bill. And we also have a panel on the forced marriage provisions covered by the supplementary LCM, the Antisocial Behaviour Crime and Policing Bill. We've also deferred, as you know, the offensive behaviour football match and threatened communications consideration, and 2 or 3 SSIs just to add to your little melee of items for next week. We'll start at 9:30. We'll be glad to know you've only got 1 meeting next week because you've been so good. I then close the meeting. Thank you.